Welcome and good afternoon. This is the April regular Board of Adjustment. We're excited to have you. We'll start by asking staff for any announcements we have today. I don't think there's anything. All set. Good deal. We'll do a roll call of board members to start, and then staff.
Joel Mazelis.
Paul Wilsinski.
Greg Allen.
Andy Ball.
Greg Phillips.
Gabe Quisenberry.
Mark Diaz.
Dana Alley.
Savannah Glantz.
Amy Broughton, legal.
Tarana Sauter.
Griffin Kearns.
Thank you. We'll move to item D, approval of meeting minutes. The board does have one set of minutes in our email. Any thoughts, comments, motion on the minutes?
Move to accept the minutes.
Second.
There is a motion and a second to approve those minutes. All those in favor, please say aye.
Aye.
Any opposed, nay? Thank you. Next, we'll move to disclosure of ex parte communications. To clarify, that means that any member of any board exercising quasi-judicial functions pursuant to North Carolina General Statute shall not participate in or vote on any quasi-judicial matter in a manner that would violate any person's constitutional rights to an impartial decision maker. And permissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, close familial, business relationship, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. So if that applies to you for any of those cases today, we'll go around the horn and clarify that.
No.
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 No. No.
No.
No.
Thank you for that. Moving to our public hearing section for today. This hearing is a quasi-judicial evidentiary hearing, and that means similar to a court hearing, state and local law set specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon the competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts presented and standards, not personal preference or opinion. Matters of personal knowledge and specific facts are acceptable, but opinion and speculation about traffic, impact on the community, crime, etc. is not. We do value a transparent process and encourage the community to remain engaged and participate, but given this is a hearing on the record, there are certain topics and areas that limit the type of testimony we can receive from members of the public without standing. Expert testimony is defined for certain topics as testimony from expert witnesses. These topics include projections about impacts of property values and projections about impacts of increased traffic stemming from the proposed project. Individuals providing expert opinion testimony must be qualified as experts to the board and provide the factual evidence upon which they base their expert opinion. As a reminder, witnesses should provide factual testimony as to how the project does or does not meet the standards, and the board must base its decision upon evidence in the record, not personal preference or opinion. Moving now to our public hearing section under ZPH 2026-00014 and 00016, Southern Towers. We're going to hear the variance first before the special use permit. And we have Ms. Phillips ready to present the case. I wonder if we've got the applicant or the representative here currently. We do. Thank you so much. We'll start with Jillian. Thank you. We have Savannah Glantz today to present. Thank you.
Yes, it's spring break this week, so
That's
I'm
right.
here in her stead. So, Savannah Glantz. I do. So I will present these just back to back. The first, let's see. So I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code. Ask that all applicant and staff materials be accepted into the record as evidence.
Any objections? So ordered.
Thank you. So the first part of this is the review of ZPH 2026-00014, Southern Towers, Woodmere. Variance. The applicant is Patton Hahn of Baker Donaldson on behalf of Southern Towers. The project is located at 2049 Upper Laurel Drive. Total acreage is 135 acres. The project will be serviced by public water and septic. The property is owned conference resort with no overlays present, and this variance application proposes an increase in the height of 54 feet to allow a 150-foot monopole. Yes, of course. Thank you. Thank you. Good? Too loud? Okay. Do I need to start over?
I think.
All
yeah,
right.
If you would.
So again, this is the review of ZPH 2026-00014, Southern Towers Woodmere variance. Applicant is Patton Hahn of Baker Donaldson on behalf of Southern Towers. Project is located at 2049 Upper Laurel Drive, and the total acreage is 135 acres. Project will be serviced by public water and septic. The property is owned conference resort with no overlays present, and the variance application proposes an increase in height of 54 feet to allow a 150-foot monopole cell tower with a 4-foot lightning rod. In addition, I don't know if it'd be appropriate to also go over the special use permits since they both tie in together.
I think we should. We're going to hear one after the other with the same applicant.
Okay, so I'll also go over this one. So for this one, I also certify that this part of the public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code, and I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so accepted.
Okay. So this part is the review of ZPH 2026-00016, also Southern Towers. Applicant is Rob Mears of Falk and Foster on behalf of, New Wave Ministries. Project is also located at 2049 Upper Laurel Drive, and the total acreage is 135 acres. Project will also be serviced by public water and septic. Property is owned conference resort. The special use permit is for a telecommunications tower proposing a wireless telecommunications facility, including a 150-foot tall monopole with a 4-foot lightning rod within a 45 by 45 fenced compound area. They are asking for no deviations. The deviation you may think of is with the variance application. That's for the height. If approved by the board, staff recommends the following conditions of approval. Project must be constructed as depicted in the site plan. A telecommunications permit must be submitted and approved prior to submitting the site plan permit and submittal for building permit. Prior to the commencement of land disturbance and construction activity, the applicant shall submit a site development permit for the project. The board could approve the natural vegetation on site proposed instead of landscaping, and that the applicant must agree in writing to these conditions prior to the commencement of site work.
And our understanding from the documents submitted is that the ordinance calls for a 100-foot max in this area for a cell tower, and that the application for the variance is for 150 feet. Is that correct?
Correct.
Okay.
Yes, the 150-foot monopole with a 4-foot lightning rod.
Okay. Are there questions from the board for staff at this point? Okay. We're all set. Thank you. Is there anyone here to speak, to assert standing in the matter, to assert standing? Going once, going twice. There'll be an opportunity later on in the hearing for witness testimony if you're here to speak for or against the project. But anybody to assert standing as to be a party to the project, to the hearing. Okay, thank you very much. The applicant can approach now. Yeah, and we'll introduce and swear in first. Yeah, up here is fine.
Good afternoon. Can everybody hear me? My name is Nick Steinhaus. I'm actually a colleague of Patton Hahn, and I'm appearing on behalf of our client, Southern Towers. We came here today to request a continuance of this hearing. The application was originally filed on February 5th of this year, and it was for a special use permit only, based on the understanding that the district height limitations did not apply to communication towers. It's my understanding that there was some communication between my client, the representative, which was Falk and Foster at that time, had some communication with Jillian Phillips, and everybody was under the same impression that the district height limits did not apply. They were subsequently informed on March 2nd, I believe. Let's see here. That's correct. On March 2nd, that a variance would be necessary and that the district height limitations did apply. So instead of the March 11th hearing that was originally supposed to take place for the SUP only, it was then pushed to this meeting. The anchor tenant for this tower is Verizon Wireless. They have agreed to provide a RF engineer who will provide expert testimony as to the need for the additional height that we are requesting for the variance. And in order to present the board with the best case and allow you to make an informed decision, we're requesting that we have the matter continued until the May hearing. They will also be preparing some additional due diligence during that time that would further support the variance request.
Because the variance has to be heard before the special use permit, we're looking at moving both of these matters.
Yes, sir.
forward. And the next regular meeting the board has is on May the 13th, if I'm not mistaken. Is that right, staff? Okay, Wednesday, May 13th. Is that a date when we think the RF engineer can?
Yes, sir, and it was a very late conflict, but we notified them well in advance of the next hearing date, so this will not be an issue in May.
Perfect. Do you all know yet whether you plan to conduct any kind of neighborhood meeting, community meeting about this at all?
I don't believe so, but unless that's recommended, but it's my understanding that, we're on a 135-acre parcel. We're pretty well removed from surrounding properties, so our hope is that while a traditional, smaller size parcel would warrant maybe a neighborhood meeting, that it wouldn't be necessary in this particular
I want to
case.
open up in case you had already decided to do one.
Yes, sir.
That sounds good. Any questions or thoughts from the board? All right.
And we understand that slots are limited for these things, and we sincerely apologize for the late notice.
Sure. And the staff will propose and we'll decide in advance of the meeting on the ordering that day of the cases. So,
Okay.
is there a motion regarding these two items? We need to push to a date certain, of course.
Motion to continue to the May regular meeting.
All right, there's a motion to push these two matters to that May regular meeting, and a second as well. Any discussion? Yes, please. All those in favor, please say aye. Aye. Any opposed, nay? Thank you. That passes. Thank you, sir.
All right, thank
See
you all.
Next month. All right. Next case is ZPH 2026-0001, sorry, 00001, Bleumont Section 1 Special Use Permit. We have Thana Alley to present.
Dana Alley? Yes. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so omitted.
This is the review of ZPH 2026-00001, Bleumont Section 1. The applicant is Ashton Smith of Kimley Horn. Project is located on 10 Silverwood Farm Road, and the total acreage is 3.17. Development is served by public water and sewer. Property is zoned open use with no overlays present. Special use permit is for the development of 168 multifamily affordable apartment units over 7 structures. There are no deviations requested. If approved by the board, staff recommends the following conditions of approval, which I will summarize. Applicant must coordinate with MSD to meet requirements of off-site easement acquisition, pump station, force main alignment approval, gravity sewer plan approval, and fully executed DOT encroachment. Project must be constructed as depicted in site plan. Prior to commencement of land disturbance and construction, the applicant shall submit a site plan review permit for the entire project. Applicant must agree in writing to these conditions prior to commencement of site work.
Any questions, comments from the board?
Question, just a clarification on the acreage. Again, how much is the acreage?
I have it written as 3.17 acres, but I do believe that is off.
Yeah, no, I'm looking at the application and it says 17.98.
Yeah, I think that's a holdover from a different project.
So which
That's
one
my
is accurate?
apologies. The one that's actually in the documents provided would be the accurate one.
17.98. All right, thank you.
All right, any others? Thank you so much. Is anyone present wishing to assert standing in this matter? We'll have an opportunity for witness testimony later on in the hearing if you're for or against the case. But if you want to participate in the hearing as a party with standing with rights to cross-examine and present your own case, let us know at this point. Standing. Yes, sir. Please approach. There's a microphone up there. You'll speak into it, and then we'll do a swearing in before we introduce you.
Robert McCurry.
Yes, Robert.
Yes. Ms. McCurry, how are you?
All right.
We'll do a swearing in.
Hello.
Yes.
Please raise your right hand and state your name.
Robert Keith McCurry.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes, I do.
Okay.
Welcome, sir.
Yes.
If you just want to go through briefly your reasoning for asserting standing today, rather than your whole case in chief, just your reason for that, why you believe you deserve
Reading
standing.
from my standing, pull out my sheet here. There is a easement that's I have in standing. It is an easement that Duke Energy has that is on my property and also on this property adjoining us where the development is at. Without stating the whole thing, I'll try it briefly. Back on January 21st, I had Duke Energy come from this property. Duke Energy had built a new switch station.
Sure, I hate to interrupt, but can you, rather than go into the case, can you talk about the reason why you might qualify for standing?
The reason I might
As in-
qualify for
yeah.
standing is, I do not want, I want to see that these easements are properly put in place. Duke Energy closed that road out. They did not have the easement. They closed it out. They went back to the property owner to get the permanent access easement through his property. I want to make sure that these easements are in place and recorded at the Register of Deeds office prior to any special use permit being allowed. I do not want the property owner or Duke Energy to try to come back and reopen this road that they crossed on my property. I want these easements in place, signed, and registered at the Register of Deeds office.
Just to clarify on this, your property abuts the subject
Butts
property?
right up to it.
And, well, from what direction? What? kind of
It
orientation?
would be from the north. The property would be the south of me.
And again, I hear, so there's some proposed easements coming up, but do you have a current recorded easement?
There is no recorded easements for this substation or this switch station, nor the permanent access road to it.
But your understanding is as part of the plan to just construct it, they need to access your property?
Yeah, they are not going to access my property to get to this switch station. I want to make sure Duke has the right easements from him to come across his property, not mine.
Right, but you're stating that as part of the plan, you believe they need to access your property?
No,
plan to.
I don't want them to. They had already cut that road in on me without easements to access his property.
They cut a road across your property?
They cut
yes.
across, they come from him and cut a road into my property with
Okay.
no easements.
Yes, would you have something?
Just while we're on this topic.
Just the microphone.
So while we're on this topic, I just want to be clear, in order, I think we're
Excuse
right
me,
now-
before you start, could you identify yourself?
Oh, I'm sorry. My name is Brandon Freeman. I'm an attorney representing the applicant for this special use permit. And the microphone
Thanks.
might not work in the stand. Does the board mind if I address the board sitting down?
You may, yeah, go ahead.
Thank you. Thank you for that, Mr. Chair. I'm Brandon Freeman. I'm an attorney representing the applicant for this special use permit. I think what we're looking at right now is, does this gentleman have standing based on an easement right in the property? And I just want to address that really quick. I don't think he's saying that he does, and we do not believe that he does. He does not have an easement interest in our property, and he's had a dispute with Duke about an easement that Duke claims or thought they had on his property. My understanding is he's resolved that with Duke. It will be up to Duke to figure out how to do an easement for this property if they need it. But I think we can move on to the next part in the analysis as to whether he has standing, because I don't think that he's asserting that he has an easement interest in the property.
No, but I think it's the opposite. That's what I'm hearing. What I understand is that he's saying that to construct this project, that you all need to access his property. There's a proposed easement for that. Is that not right?
That's not
That's not
accurate.
accurate.
I mean, and we'll have folks get up and testify about the actual facts of the thing now, but that's not accurate. I
Okay.
do not think they're intending to use his property.
Okay, thank you. Yes, sir.
Yeah, see, that's what I want to make sure. I don't want my property accessed to get to his property. And I want to make sure these easements are in place with them and Duke.
So the board, just to clarify, the board can't get involved in any easement, dispute at all, but we do need to hear as far as your standing application on this matter, whether you think that you have special damages or might have special damages as a result of the construction of this property, how this construction as proposed might affect your property.
Okay, well,
And
that's.
you speak to that.
Yeah, I can speak. There's more in here to my standing other than just this easement. And the proposed property butts right up against my property. And we have several wells that are up there. And there was a study done by the people that's wanting to build the development, and that study was wrong. They had claimed that there was no wells within 100 feet of the proposed site. Well, there are. There are wells upwards of 8 feet, as close as 8 feet to this property. And we butt right up against it where this 17 acres of the first phase of this project is going to be, of the 168. There is, according to these drawings that we've got, I don't know what setbacks are going to be there, but there's going to be this grading and these retaining walls put in, and it is going to affect our well water up there. There is a total of 6 wells up there. And like I say, 3 I have listed with the closeness of the proximity. And there is not going to be enough groundwater saturation from the top. We're going to lose this as far as asphalt and concrete and buildings sitting right there, right on top of our property. And
If the proposed project impacts your wells negatively,
Yes.
what is the result of that for you?
we would have to be forced to go on city water. And who's going to pay for that? And get the city water up to our homes up in there. That would be the impact and of this. That's what our questions is. We want a third party to come and do a study to see what the actual impacts would be, or redo these setbacks to where they're at least far enough away to where we have groundwater saturation that the ground can take this in. And
A question for staff on this legally is, we're still in the realm, we're looking at standing application here and the 4 qualifiers for that, and this seems to fall in that range. Am I not mistaken?
I would actually agree
Mr.
with
Chair, may I object
After
before
this.
we get into that
After this.
analysis?
Yeah, after this.
you. I would agree with the chair.
The objection would be to his lack of knowledge to provide the testimony. He has not laid any foundation for the wells. He's also not been qualified as an expert in how wells operate and whether this would impact the project.
That's
this
a
is the reason
separate
why I
issue.
want a
That's
third party.
That's a
Sorry,
substantive.
please.
That's
Yeah.
a substantive issue, not a procedural issue.
Right.
So procedurally, I believe that he does have standing. If he chooses to call witnesses to support his position, then that's a different
Right,
matter.
Exactly, yeah. Sir, did you have evidence today to present on the actual effects of this on your
That's
property?
what I was asking this board for a continuance so we could get this expert
Okay.
analysis in.
Board questions?
Can-
Sorry,
I'm-
please. Board questions?
But just for clarification, should you be granted standing, you are prepared to bring forth experts that will substantiate what your claim is for damages?
Yes, I can, I mean, not today, I don't have that today, but.
Correct.
I
Correct.
mean,
So
I'll be prepared to have a study done and get experts to do this.
Okay.
Yes.
All right.
Most definitely.
Other board questions, concerns for?
Yeah, could you tell me approximately how long you've known about this project?
Since September of last year.
And can I ask why you haven't had the study done between September of last year and now?
Well, I didn't know if I was going to be required to do something like this or not. I would like the opportunity to do it, but
for clarification, was the date that you referenced the beginning of the applicant's attempt for annexation from Weaverville?
yes.
And so what was the date in which you knew that it was coming to the Board of Adjustment here?
Board of Adjustments, it was back in January.
All right, thank you.
Other thoughts? Okay. Yes, sir, Mr. Freeman? Yeah.
Yeah, so it's not enough to come in and say I have concerns about a very scientific matter. You have to come in and say, I am qualified to tell this board that there's an actual issue here. So if the board grants standing in this case, they are taking a lot of assumptions before they do that. First of all, that he's correct about measuring. So there is a whole body of North Carolina law that measures how close a well can be to a thing, right? He is talking about a measurement from a property line. We are talking about a project, right? We also have an engineer here today who is prepared to testify, and I think that this engineer should testify to this board at this standing phase so the board can have some expert testimony as to know, is there even an issue at all with these wells, right? So the wells that he's talking about are uphill from this development, right? They are 50 feet away from where any work's going to be done, or more than 50 feet away from where any work is going to be done. There is nothing in the environmental health law that he can point to, and if he can point to it, maybe we have something to talk about. There is nothing that he can point to that he is going to be able to come back to this board and say that this development is not allowed to happen next to these wells. This is a tactic to delay the outcome of this. Now, we do not object to him participating in this hearing as a witness and asking all the questions he wants to our engineer, but he has not made a showing of special damages such that he can be granted standing in this hearing today.
Yeah, one small comment. If he appears as a witness, he can't ask questions, right?
We would consent to him asking questions. That has always been our practice.
Well, we'd have to
Every
consent to him
project
asking
for this
questions
board.
too.
Yeah, we're not going back and forth right now in the standing hearing on that. But later on, if he's admitted as an applicant with standing, then yeah.
If he's admitted at.
If he's admitted, yeah.
Yes, but
But
if
the board has
he's
to decide,
not.
the board has to decide on standing before we get into details about the case. Yeah.
No, I think the
So I don't agree with what was just mentioned about us being able to hear specifics of a matter. The standing application comes first. Does the board believe he has standing? Period. Yeah. So we can decide that, and then we can decide whether we want to continue or not. That's up to the board. Yeah.
And I'll just say, I think you all have this book. This book specifically says, at this standing phase, you have to put forward, if you are saying I have standing because of an expert required level issue, like I have standing because of traffic, you need to have a traffic engineer here to say, this is why I have standing. This is exactly the same thing. He's saying, I get standing because this is going to, for geological reasons, impact my well. Because of that, he has to have something more than just his lay testimony saying that's a fact.
I think I would agree with that statement, but I would say that he said he'll bring an expert at the next meeting. That's up to the board to decide whether they want to allow that, right?
Well, I
Would you
think
agree?
that if the board wanted to continue, well, so.
He doesn't have to have the
order-
expertise, but his professional could.
He would have needed to have brought that professional here today.
To
in
hear
order
the case
be
today.
Granted that standing. So it's, I get, he's known about this for long enough to where he could have done that. He could have brought his expert in here today and be ready to rebut it. He came in with lay testimony. We've got a room full of experts who are, our client who is doing affordable housing is paying to be here today. They were ready. To delay this project is not fair to them. He had the notice he needed to have his expert here.
Okay. Anything else you want to say to close up your comments?
I would just like standing to be able to get expert testimony.
And the last question I have, just can you describe more detail about the hardship you would have if the project were built as is, in your belief? More detail about
In
that.
my belief, well, with the well situation, the water situation, and then I also had another standing that I wanted to go in, was my business is up there. And I've had that business there for 30 years, me and my wife have. And it is set right on the property line, and like I say, it's going to be right there. I make a lot of noise up there, a lot of trucks coming in and out. It is like, it's air guns, equipment that I run all day long. And I know that noise is probably going to affect them over there if this is built. I want to know what kind of barriers, this may not give me standing or not. I want to know what protections I'm going to have from the developer to assure me that I'm not going to be, have the Buncombe County, you guys coming up, writing me tickets or warnings because of the noise that I have. And that I want to know. I want to know what protections that the developer will put up, soundproofing, whatever.
Just a question on that.
Thank you, sir.
I just want to make sure I understood what you just said.
Mhm.
You said that you make a lot of noise, right?
Yeah, with running equipment and,
Okay, and you want the developer
What?
to pay,
well, I mean, I want to know what kind of protections we're going to have up there.
well,
I mean,
if you make the noise, why don't you provide the protection?
I mean,
I don't understand your argument.
well, I want to know what my recourse is. That's all I'm asking. What is, I mean, if I have to put it up, I guess I have to put it up.
Yeah, the board doesn't have any purview over the noise ordinance at all, but the county, county still does that separately, another department.
Mr. Chair, may I be
Yes,
brief?
please.
So I agree, that's a first for me. I don't think I've heard of someone saying, I'm pretty noisy for this development coming in, so I need them to protect themselves from the noise I anticipate making. That said, I understand how the county usually addresses, instances where people move out to something noisy and then complain about it. So we know that may well fall on deaf ears. But, we nonetheless will expect any neighbor to be reasonable with the amount of noise they make and adhere to the noise ordinance. But as the chair said, that's for a separate issue. One thing I want to highlight is in this standing application, he talks about operating a tractor trailer business where you can see tractor trailers. There's a lot of tractor trailer parts lying around, a lot of old tractor trailers laying around, things like that. So I think that this might highlight how much there is a concern about groundwater contamination here. The project that we are going to develop is going to be highly engineered, and all of our groundwater is going to be collected and managed like a stormwater ordinance says it must. If there's anything that's going to endanger the wells on that property, I would state to this board that it is old tractor trailer engines and tractors laying around on the property.
Thoughts from the board?
Sounds to me, I'm sorry, go on.
I sense based upon the location of Mr. McMurray's property and his statement as the owner of the property with regards to the location of the wells and the proximity of those wells to the development, that all of the other issues set aside, that is what qualifies him for standing. He's going to suffer damages, health, loss of utility, water. If he can find a recourse, costs for city water, and all of those things are unique to Mr. McMurray.
I see the same thing, yeah. Paul?
It sounds to me like the gentleman is requesting standing so that he can get a continuance. That is all I really heard here. And
So you can present competent evidence, expert testimony, yeah.
at some, well,
You're right.
It doesn't even matter, right? He wants standing so that he can ask for a continuance for whatever reason, which isn't a valid reason to give him standing. I mean, he said, I think I may be damaged because of this, and I think I might be damaged because of that, but he hasn't presented any evidence that he's going to be damaged. We may think he's going to be damaged, but as we sit here, we have no evidence that he's going to be damaged, so.
Yeah, during the standing hearing, we don't hear the evidence that he's damaged. We hear an allegation of special damages, and we've heard both a public health issue with wells, and I've heard
Well,
that,
his
at least.
opinion on it.
Correct. All you have to do is allege it. You can't present the evidence during the standing hearing. You had to wait till he's given standing.
Right,
and
but
then
he said
presents
he
it.
doesn't have evidence to present.
No, but he might have it next meeting, is what he's saying. So the board would have to decide first on whether has standing, which is a separate issue, then whether he wants a continuance. That's not a reason for standing. That's not the reason he gave for standing. But I would anticipate if we admit him as a standing applicant, that then we would hear a request from him to move the hearing to next month. That's what I would anticipate. That's what I heard.
Request without him standing.
No.
Not.
He would not have
No.
he's not a party to the.
He couldn't make a request to continue the hearing as a layperson. So, no. Joe?
Yeah. Yeah, and when you knew this project, have you sought legal counsel and expert witnesses?
I have on the Duke Energy legal counsel on that, but not counsel
So you
on
don't,
expert
you haven't
witness.
retained legal counsel?
No, I have not retained,
Okay,
just
how about experts?
experts? No, I have not.
Okay. Then I got a question under supplemental documents. I get water from Weaverville, and I'm not in Weaverville. So I had to go through a process to get approval. There's a document here under supplemental documents dated February 5th, 2006, and it says the project has approved water from Weaverville, unless I'm misunderstanding it. So maybe there's some clarification, because you're talking about wells. Is the project getting water from Weaverville, then is the well issue irrelevant?
Mr. Mazelis, I can answer that. Yes, this property is getting water from Weaverville. It is getting sewer from MSD. There is, so to read from the School of Government here, sorry.
Joel, just while he's looking that up, my understanding is that Mr. McMurray is alleging that the construction of the development would impact his wells. The city water will be provided to the development, but Mr. McMurray does not have access to city water. He is on a well or wells. And the belief is due to runoff from the construction, the finished site, and the actual construction itself could potentially impact his well.
So he is to the north and uphill of the site, so there's no way that runoff water is going to impact his wells.
But again, that would be
And-
testimony that would come at some point.
No, it is up to, so here from the School of Government, the essential element is a credible allegation of harm to the use and enjoyment of the particular property. And this is to get standing. It's not a showing, it's not an allegation. It is a showing. You must show that this is going to happen to you. You must make a credible allegation. It's not a speculative allegation. What he has to show this board is this is going to happen. And it's just not. His wells are far away from the property. The runoff is going to go somewhere else. This property is not going to affect the ground table because they're getting their water from Weaverville. And the sewer is not, there's not going to be a septic filled because it's going to be going to MSD. There is no credible allegation.
Mr. Chair?
I would disagree with it, yes.
I think you have a good grasp on the procedure here, but this is because the questions that were asked, Obviously, first, they're standing. If, then you would address the issue of the motion to continue. You could theoretically grant standing but deny the motion to continue, in which case Mr. McCurry would still be permitted to participate in the hearing, but it would go forth today.
Yes.
You, of course, can grant both of those things. But I just want to make sure that we were clear, because there were questions about how long have you known about the hearing and this and that. I think
Sure.
that would go to the issue of the continuance, not to the issue of the standing.
That's part of sort of why I'm kind of taking temperature here and seeing what the board thinks right now with regard to that, because there's two questions separately, yeah. And first is whether the applicant has standing. So that was sort of an answer to your question, Joel, I think. I think so. Other questions, comments?
Just a clarification, Mr. Chair, are we at a point where we are posing questions to the applicant and to Mr. McMurray, or are we in board discussion regarding?
We can still pose questions, it's not closed.
All right, thank you.
Any other comments, questions? The board? Okay, one last, anything else you want to say?
Yeah, I had one more, but whether or not this grants me standing, I don't know. But it was due to the fire marshal and fire department's report that was not turned in, but I turned it in with my paperwork as to being a detriment to the community as well. I do have one document that could be considered as expert testimony. I would like to read that. This is from the town of Weaverville. This is their staff report that was on this project here.
We would object to this as inadmissible hearsay.
Wanna hear
Not
more
sure
before
what's
we-
in it.
Overall, want to hear more?
You want to, I want to read this. This is a legal document. You can go to the website and see this. This is due to the fire. These properties are located within the North Buncombe Fire District, which is serviced by the Weaverville Fire Department. This project does represent an increase in population density and structures and will have a significant impact on fire and emergency services, traffic patterns, and overall community safety. There has been substantial rise in call volume, and it gives the list of the call volumes here. And this development will accelerate that upward trend. Overlapping calls place community safety at risk and are expected to surpass 25% when this development comes online. The expected increase in traffic congestion will impact emergency response times. The proposed daycare center will require additional fire and life safety considerations to adequately serve that vulnerable population. Weaverville Fire Department staffing and department resources will need to be reevaluated, and the addition of another company will likely be needed when this project is added to the expected needs of the pending projects, including Northridge Farms, Maribel, and Advent Health Hospital campus. This additional company will not only address the increase in overlapping calls, but will also strengthen the operational effectiveness of the Weaverville Fire Department, particularly in responding to structure fires and other complex emergencies.
What was the title of that document?
It is Annexation Staff Report Summary 25-1. It was part of the packet, the Weaverville Town Council's packet.
It's not part of the applicant's submission here, it's a public document from the.
Yes, it is a public document.
And what is the assertion there? How it relates to this case?
Adding these extra firemen to cover this development will put the tax burden on the taxpayers, because this is a low-income development, and Buncombe County will not receive property taxes from it. So,
I don't see
how
I'm not
this-
sure how I'm not sure how you would be an affected party here in that relation to that issue at all. So we're gonna
that's,
move past that. Yeah.
that's fine.
The only thing I would say, the only thing is I'm thinking is, and again, it's a stretch back to making this from a standing question, is whether the lack of fire protection for this property would potentially harm Mr. McMurray's property.
Your property only.
Your property, because of a fire that is uncontrollable because of the lack of.
Okay, but it has to be his property only.
It would affect your property and your neighbors in the same way. Yes. So it's not relevant. to this.
Everybody, yeah. This is not special damages.
So, okay, the board's ready, I think, at this point. Any discussion on standing application here, or is there a motion?
I've heard feelings and theories and thoughts, but I haven't heard any evidence that would give him standing, aside from the fact, aside from considering he happens to be right next to the property, but being right next to the property is no, you know, it does not automatically say that he's going to be damaged, right? The fact that he's right next to the property. So I am not in favor of this.
Okay. Joel?
Yeah, one thing here, what you just read about safety regarding fires, it mentions a lot in there, the consequences. It doesn't mention the service taking any action against the development. They may be short budget to offer the proper protection, but, you know, that's something I think beyond what the board could do with this. And the fact that, again, there's no one from the city of Weaverville or the fire department to come and testify that this development creates a public safety issue. You have the document, but I don't believe it said in there, this is a public safety issue problem.
Thank you. Thank you.
Is this the only adjoining property that's on a well to the project?
We don't know, yeah.
I mean, I'm having a tough time getting to the special damages.
It would just be the distance from the property to the actual structures, actually, to his wells, so.
There was a study done by Kimley and Horn. I'm not sure who prompted that study, but it does mention a study about the well water in the surrounding area, but it only addresses that on Squirrel Hill and Squirrel Ridge and not actually where Mr. McCurry's residence is. So I thought that was a bit off there.
Again, as I look at this, we got two questions that we need to answer. The first one is whether the gentleman has standing, and then the second is whether we need to give him time to bring forth expert witnesses. I think back to, in my opinion, in the time that I've been on this board, this gentleman has pretty clear potential harm. And it's unique based upon the location of his property, and the location of the development and the proximity to the property line. So I'm not saying that my support for his standing goes carte blanche to continuance, but I think from a technical standpoint, the gentleman qualifies for standing.
I guess I would agree with that there's an allegation, credible allegation of special damages due to the proximity of the property and the wells to this project. So that's the only way I see damages that have been alleged right now. So, yes, Joel.
Yeah, I would vote for standing just to make sure I got all the facts, you know, that he brings in as experts, and this issue just brought up about public safety. I'd like to hear from the city of Weaverville.
That issue is not one that I believe does qualify him for standing as far as the fire marshal letter and all that. That's not something, and the board can certainly, allege that or talk about that some more, but it's not been included in the umbrella of what's considered a standing matter. It's the proximity of the wells, is what we've heard so far.
May I be heard
And
on
I
the
would-
fire
I think we're ready to rule. Yeah.
Okay, I just have one other comment. I just want to mention what Joel said. We aren't going to get any more facts unless we grant a continuance.
Separate issue, yes, you're correct.
Mr. Chair.
Separate vote.
Respectfully, I just want to have
I'd
an
like to bring
objection
forth a
noted
motion.
so we have a
Let's hear your
clean
objection.
record.
Let's hear your objection.
Right,
Yeah.
and I'm sorry, it's just important that if I don't make this
Let's
objection
get it on
now, I
record,
might not
yeah.
be able to make it later.
Right.
So I'm worried that the board might be considering the testimony or the letter that was read about the Weaverville Fire Services. So first of all, that's kind of a classic. It's an issue that affects everybody. We all want to make sure that we have sufficient firefighting resources to address our properties. The reason that document was brought into being is because at one point, this property was was proposed to Weaverville for annexation. That didn't happen. So there's not it was a different proceeding, a different project. It has no bearing here. So this would be a property, obviously, that was in the county. The county is right now going under a whole redo of how it does its fire district taxes to, potentially, to change things. That's where that gets addressed, not here.
Thank you for that. Any questions about any clarification needed on board members for that? Yes.
Yeah, just to clarify, we need to grant standing in order to address a motion for a continuance.
That's right. There's a motion. Is there a second?
Second.
There's a motion and a second. We'll go around and do an individual vote on this one. Joel?
Yeah, I agree, grant standing.
Okay. Paul?
No.
Yes.
Yes.
No.
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 Yes.
4-3 that applicant is granted standing in this matter. Do you want to make an official request or motion about the continuance of the hearing?
Yes, I would like to make an official
Purpose for that.
motion for a continuance of this hearing till I can get an expert on the wells.
The next scheduled meeting of the board is May 13th, a Wednesday. That's a month away. Is that a reasonable timeframe?
I think so, yes.
Comments, thoughts from the applicant?
Yeah, we would object to continuing this matter. This applicant had notice of this hearing. He's told this board that he knew about it for a long time. We have an engineer here today that he can ask all the questions he wants to. And I tell you, I think that this is a fair approach. Let's have our hearing, and when the engineer gets up, if there are unanswered questions, let's readdress it then. Because we have, first of all, in his packet, he provided an engineering report from our engineer. We have an engineer from that firm today ready to talk to this board about the issue. If there are still questions, we can look into whether we need to continue it later. But I think, this is a company who focuses on providing affordable housing. They've come here today with all of their experts. They have a presentation ready to give this board, and I think they should be allowed to do that. That said, I understand he is a party with standing, and I want him to be able to ask all the questions that he has of our engineer.
Right.
Qualification, a question on what you just proposed, if I heard it right. Are you saying you would not object to Mr. McMurray's request for a continuance if in the course of hearing your expert witness, he believes that there is counter evidence that would be of benefit to this board?
I think what I said is we should wait until we hear that testimony from the engineer to make that determination. You've heard only speculative information from this witness. We have an engineer here to talk about it.
Correct, but then I also heard you say if he challenges or has questions of that engineer, he could bring forth his request for continuance at that time.
I think that the board can listen to how his conversation or examination of the engineer goes. And if the board has questions, the board thinks it needs more information, then we should have the discussion about a continuance. But I think that we should have the hearing today.
I concur. He doesn't need to.
But does the board?
He's not the judge. We are.
Just for
We hear the
clarification for the board, do we have the authority to request a continuance?
Yes.
Or is
Yeah,
it
we
the
can
applicant?
Yes,
continue
we
if
can-
don't
we
have
can do it.
information.
If
Yeah.
we do?
Yeah.
All right.
Yeah,
Yep.
sure.
Thank you.
Sure. Joe?
Comment, this is for county legal staff, because I hear it continuously. Yeah, we need affordable housing, but does that come under the purview of this board to consider that as a factor?
The affordability of the housing is not a factor that the board would consider in making its determination.
Okay, thank you.
Other comments from the board? Okay, we have a request to continue the hearing from Mr. McCurry. Is there action on that the board wants to take?
Bring forth a motion to deny the request for continuance and proceed with the hearing as we have it scheduled today.
Okay, is there a second?
I'll second that.
All those in favor, please say aye. Aye.
Aye.
Any opposed, nay? That passes. Thank you very much. We'll continue on with the hearing today, and you can have a seat over here, Mr. McCurry, at the other table. Yeah. And we'll introduce the applicants at this point.
Thank you, Mr. Chair. I was looking over at the table for staff to see who was going to introduce the project, but I think that already happened.
Yeah, I think we're good to go.
We'll have I'll provide a bit of a refresh. Let me plug in here. All right. All right, so you heard from Thana, who's already given you an overview of the property. I'll just recap. We're in the open use district. This is currently vacant land. You can see it highlighted in this picture. There are no applicable overlays. What we are proposing here is 168 affordable apartments units spread over 7 structures. Can you all see a mouse if I move it? I'm not sure if you can. Yeah, okay. Yeah, so this is North Buncombe High School, where my mouse is. If you go down, this is North Buncombe Middle School, and I think this is Windy Ridge Elementary School. So we're right in the middle of a bunch of schools. Before I get further, this is not intended to be testimony on my part. This is all information from public records. We've got our experts who are going to come up here and provide testimony as to this application. And this is the parcel we're talking about today, or the project area. In that large parcel, we're talking about a much smaller project that's highlighted in the second image. I do this most of the time. I come before this board or any board, look at your comp plan. So it is not an element. It is not relevant to the issuance of a special use permit. Whether there's compliance with a comp plan, that is something that zoning boards look at. But I still think it's nice to look at them. We are in a mixed use neighborhood district. The red arrow is pointing to where we are. This is the kind of stuff that you would expect to see in mixed use area, medium to high density development. This is, even though it's in pretty far north Buncombe County, it still has access to public transportation. So it's within about a mile of the Trailblazer Loop, which is a Buncombe County service that is provided to connect folks in the county to the Asheville transit system. That's enough for you to hear from me. I would like to bring up our engineer. Cody, can you come up with us? Or, I'm sorry, Landon, let's get you up here first.
Hi, good afternoon. My name is Landon Cox. I'm the development manager.
Please raise your right hand and state your name.
Sorry.
It's okay.
Landon Cox.
Okay. Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Okay, thank you.
Sure. Landon Cox with LDG Development. LDG is the developer of the proposed community that we're talking about today. I'm the development manager for the company and oversee all of the development that we do in the state. Our company is primarily an affordable housing developer. We've developed around 25,000 multifamily units across the southeast, most of which, probably north of 90%, are affordable housing units. The company has been in the state, operating for about the past 5 years, have 3 communities that are under construction at the moment, one of which is in Weaverville, fairly close to the project that we're talking about today. The location, when we think about where to place the communities and where would be a good location for the sites that we're going after, there are a couple of things that we look at. One of which, and I think this was getting at Brandon's point, is proximity to amenities. And there is a scoring system that is that the state housing agency has, in which you rate the location based on its proximity to things like schools, parks, grocery stores, pharmacies. And this project ranks at the maximum score when you consider its proximity to those based on the state's criteria. Another thing that we consider is need. And so when thinking about need, we will have a market study performed that looks at the region that we're likely to draw renters from. And it looks at how many affordable housing units are available in that area, how many households would qualify to live in the affordable housing units. And what we found in this case is there are about 2,300 families that live in what is called the primary market area that would qualify to live in the housing that we're proposing that don't at the moment have access to affordable housing options. So look at demand, and then we look at whether the location makes sense based on its proximity to important amenities like the ones that I mentioned. Some specifics about the community, if it's of interest. So there will be 168 units that will be reserved for families who are earning between 30% and 70% of the Buncombe County area median income. And so what that means in practical terms are the units will be reserved for families that are earning between $18,000 more or less up to around $67,000. So this spans spans folks who are on the lower income scale. These are folks that are working in the service industry, supportive roles around town, but also includes public servants, staff, healthcare staff, school teachers, folks like that. And we think that there will be a particular need that's forthcoming soon with the Advent Health Center that's coming in. So this hospital, which is about a mile and a half from our site, will bring 1,600 jobs with it. And I know from work with other hospitals that many of those jobs are lower earning jobs. So we hope that we'll have housing available for that workforce once it's in place. And I'm happy to answer any specific questions you have about the project or our company.
Before we get to the board questions, any questions for Mr. McCurry for Mr. Cox? No, okay, yeah. Board questions? Okay, thank you so much. I think we're all set.
Thank you.
Yeah.
And we'll keep Mr. Cox around in case any questions do come up. He does have a wealth of knowledge about the project and the board. We'd call Mr. Cody Tuddy, please.
Welcome, sir. If you'll speak into the microphone, and we'll swear you in first.
Please raise your right hand and state your name.
Cody Tuddy.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, sir.
Hello. So just a little background on the project.
Yeah. Yeah, let me ask you a few questions.
Sure. Yep.
Mr. Tuddy, please state your name for the record.
Yes. My name is Cody Tuddy. I work for Kimley Horn. I've been an engineer for 8.5 years, had my PE for about the last 2.5. I've worked in land development that entire time, 4 years down in Florida, about 4.5 years here in North Carolina.
Mr. Tuddy, do you have experience in site plan design?
I do.
And what area of site plan design is that experience primarily in?
It's primarily multifamily and some industrial as well.
Do you have experience in the application of local government codes to development projects?
I do.
At this point, I'd like to tender Mr. Cody as an expert in civil engineering and site plan design.
Any thoughts from the board or from, yeah, go ahead.
Has there been a resume presented for the board?
I do have a resume for the board. Mr. Chair, may I approach?
Please, yeah. If you have any extra copies, then Mr. McCurry should get one too. Yeah. Okay, sure, yeah. We'll pass it around.
Yeah.
Yeah.
Thank you.
Thanks. Okay, we can continue while we're looking at that.
We would like to tender Mr. Cody as an
Okay,
expert.
let's pass it back when it's done to Mr. McCurry. Yeah. You got one? Okay. Any objection here, Mr. McCurry? Okay. Hearing no objection, so tendered. Thank you.
Mr. Tuddy, can you, and for the producer, may we have what is on the laptop on the screen?
Thanks.
Right. Mr. Tuddy, can you tell the board what we're looking at on the screen?
Sure. It is our site plan. It's on, like stated earlier, 17.98 acres. We are proposing 168 units. That's roughly 9.3 units per acre. On this plan, you can see that we're following all the setback and buffer requirements per the UDO. And we are also providing 320 spaces, as the requirement states in the UDO as well. The UDO states 1.75 parking spaces per unit, and we're providing over that amount.
Mr. Tuddy, when you designed the site plan, did you consider the applicable requirements of the Buncombe County Code of Ordinance?
We did. We spent a lot of time looking through the UDO and other documents pertaining to what this site would need as far as setbacks and other regulations that we would need to follow to kind of put this together.
Among those ordinances, did you specifically include Division 6, which concerns special uses?
We did.
And did you consider Section 78-677B6, which concerns planned use developments?
Yes.
Okay. I'm going to go through a few of those standards. Can you just talk about some of the designs of this project that address those concerns?
Sure.
So what did you take into account for designing a project that would not have adverse effects on surrounding properties due to vibration, noise, odor, or glare?
So we designed the project to limit that stuff. We also, like you saw in the earlier documents, we did have the surrounding well studied. Kind of per that report, our construction equipment would not be in any danger of impacting any of those wells per the report. Because of the topographical features on site, we have a ridge that runs along the north edge of our property, as well as a stream that runs along the south edge of our property. So those are both geological features that kind of separate out kind of like the groundwater flows as well as surface water flows. And so we shouldn't be impacting off-site properties with any surface water flows or anything like that. Another thing that was noted earlier and at the back of the report specifically is that we are on municipal sewer and water. And in the report, it specifically states that, that will allow us to not impact nearby wells by not affecting the groundwater from the bedrock aquifer. And so, that doesn't change necessarily based off of like the adjacent properties and like where they are, but due to the topographical features, we should not be affecting them.
And can you tell us what you're reading from there?
Yeah, it is a report dated November 17th, 2025, specifically talking about the water well impact evaluation that we did for LDG.
Okay. Let's put a pin in that and we will circle back. But are you confident that you're able to talk to this board about that study and the impacts that this project will or will not have on wells?
Yeah.
Okay. So can you talk about the ingress and egress for this property and what you designed in this site?
Yeah, sure. Our main entrance is coming in from kind of the south. We are pulling off of kind of the road to our east. And then once you get onto our property, we have plenty of circulation, plenty of parking to kind of help the flow of the traffic kind of through the site.
You've mentioned off-street parking. Do you remember off the top of your head what the requirement is in Buncombe County for off-street parking?
It is specifically for our project is 1.75 parking spaces per unit.
All right, is that what you're providing?
We are providing over that.
All right. And Mr. Teddy, feel free to look up there at the board members.
Okay.
When you talk,
Sorry about
to them,
that.
they'll want
I
to see your
apologize.
face. It's all right. Can you tell the board how this property will be getting utility services?
Yep. We are getting water from the city of Weaverville, and we will be getting sewer from MSD.
Can you talk to the board about the buffering that you have designed for this property?
Yep. So on the plans that are up on the screen, you can see that our boundary setbacks are 10 feet for both north, south, east, and west, as well as buffers of 20 foot abutting the residential properties. As far as the setbacks go, our buildings are actually substantially further than that, just due to the grading constraints on our site. So I think we're about roughly 50 feet from our buildings, offset from the northern property line.
And can you talk to this board about what the plan for is to provide playgrounds, open space, yards, things like that for this property?
Yeah, sure. So we're proposing a picnic area with a playground right next to a amenity area that includes a pool. There will be other small pockets of open space throughout the property, as well as a dog park kind of on the south side near the entrance.
And can you talk about how this plan addresses needs for emergency access?
Yeah, we always design our plans to meet emergency vehicle needs as far as like the required radii, lane width, and things like that, as well as there's hose lay requirements. We may meet all those standards.
Can you explain what a hose lay requirement is?
Yeah, sure. Basically, there's a fire access road, and that's kind of where the fire truck enters and goes around our site. Typically, that has width requirements. Our widths are, I think, 26 feet wide, which is over the required fire access. And so you measure hose lay from the fire access lane around the building. And depending if it's sprinklered or not, you might need to be 150, 200, 250 feet of hose lay to cover the entirety of the building. And we would meet all those requirements per our design.
The minimum distance between buildings as required by the county, I believe, is 20 feet. Is that your understanding as well?
That's my understanding.
Okay. Do you meet those requirements?
Yes.
Okay. Can you talk about how you have designed this property as it relates to privacy?
Yeah. Again, typically with these properties, we do have a fence extending entirely around the property, as well as we do just have the one entrance.
Okay. What about the ability for buildings to receive adequate air and light?
Yes, so there are requirements from NCHFA that we follow that do require the buildings to be placed so that they receive all those.
And did you follow those requirements in designing the site plan?
Yes.
Okay. Have you followed the ordinance's provisions for perimeter requirements?
We have, yes.
Okay. And can you talk about what screening you are implementing for this project?
Yeah, so, again, per the buffer requirements, we'll be following all the, pertinent UDO, as well as because we have fencing, it'll also, have the fence on the north side and the south side of the project as well.
So, Mr. Tuddy, this is a residential development. Is there anything that makes you think that the hours of operation of this residential development would be different than any other residential development?
No.
Okay. Mr. Tuddy, I want to circle back around and talk about your education.
Sure.
You have the good fortune of looking younger than your years. That's great. I want to talk about first your undergrad experience. Can you tell us where you went to undergrad, what you majored in, and what your degree was in?
Sure. I graduated from UMBC in Maryland in 2015, and I graduated with a bachelor's in chemical engineering.
And where did you go from there?
After that, I ended up going back to school. I went down to Florida, so went to Orlando, UCF specifically, and got my master's in civil engineering there in 2019, I believe.
And after you received your master's in engineering, what did you do?
So even before I received my master's, I started as an intern at a company down in Florida, KPM Franklin. I worked there probably as an intern for 3 months, and then they pulled me on full time. Worked there for about 4 years before I decided to move to Raleigh. I've been working in North Carolina ever since. Basically, from the beginning, I've been doing land development. That's what my old company did. That's what I do at my current company. Very similar type of projects as the project we're talking about today. A lot of multifamily, a lot of industrial, some commercial, things like that.
And Mr. Tuddy, when you were in Florida, before you came to Raleigh, did you receive any certifications?
I did. I got my engineering intern certification in Florida. And then when I moved to North Carolina, I decided to sit for the PE exam. And I have my PE as well, for professional engineering license.
And before you can sit for a professional, sit to be a registered professional engineer, is there a internship requirement that you have to do?
So there is a 4-year requirement as far as work experience before you can sit for the PE, and you also have to have passed the FE, which is what allows you to get the engineering intern certificate. So there's a test before the test, and then there's also 4 years experience.
So about how many years have you had of engineering experience as it relates to residential developments?
I would say about 7 years.
And in your experience, have you dealt with issues related to wells and groundwater?
They do come up on the occasion, especially with these larger sites. They do come up on the occasion.
And when you design a site plan, do you keep the safety of those wells in mind?
We do. Groundwater is really important, I think, to everyone. And so there's a lot of regulations, both local, statewide, and federal. And so, we're always obligated to follow all the local, state, and federal regulations when designing a project that pertain to groundwater and site development.
Did you take into consideration the wells surrounding this property when you designed this site plan?
We did. And again, I think just referencing back to that study we did, it's definitely been something that we've thought about from the beginning.
The study you were referencing, it was submitted to this board in a standing application. I believe it's in the record. Does the board need a copy of it, or is it available to the board?
Let's double check. Isn't that right, Griffin?
Restate the document we're looking for?
It's titled Water Well Impact Evaluation, dated November 17th, 2025.
Yes.
Yes. Yep.
All right, Mr. Tuddy, now that document was generated because of questions that were raised about a well on a downhill slope of the property. Is that correct?
I believe so, yes. But if you look at the findings, it really is more of a broad study of the entire site.
And you beat me to it. That was my question. Would the analysis in that report apply to the well on Mr. McMurray's property, if there is one? Would this analysis apply equally to that well?
It would. And so if you look kind of in the potential for impacts to nearby water wells, which is the second page, the second point specifically talks about topography and nearby streams. And so the nearby stream is south of us. And then the topography it's speaking of is the ridge line that runs along the north edge of our property. And so, based off of these findings, it states that the topography and adjacent streams act as physical and hydrological barriers to kind of separate, our site from the adjacent ones.
Mr. Chair, I believe those would be my questions at the moment for Mr. Tuddy.
Thank you. Does Mr. McCurry have any questions for Mr. Tuddy?
Yes, I do.
Please go ahead.
States here in number 2 that you pointed out here just shortly a minute ago, you use Squirrel Ridge Road and Squirrel Hill Drive for your references for this point, or this PowerPoint here on number 2. And you said that the adjacent properties were all taken into view. When I had this question down at Weaverville, when the town was looking at annexing this, Mr. Cox knew where I lived at the time. Why isn't Ray Holler Road mentioned in this number 2 and Squirrel Ridge Road used?
I can't speak to the exact nature of that, but I can speak to the, content of that statement. And again, I'll just re-reference, is speaking to topography and stream, topography and nearby streams, helping to control the groundwater flow. Even if your road wasn't mentioned, those still apply to your project based off of the fact that, there is a ridge line that kind of runs between our property and his property.
And Mr. Curry, I mentioned this before, but obviously it's a Q&A format, so rather than testifying yourself, you'll want to ask all the questions in the form of having the witness answer them, rather than assert your own things.
Okay. When number 1 question up here on the PowerPoints, when it said no wells were within 100 feet, where did you get that information from?
Again, I didn't sign and seal this particular report, but just reading through it, it specifically talks about physical damage to the wells. And so, even though your wells may or may not be closer than 100 feet, we do not anticipate damaging the wells physically. With any of our equipment, we shouldn't even be close to your wells.
Well, as far as I see the the topography here on your map, on this blueprint here, as
Sure.
far as the surface area of this complex taking up, in reference to my well where it is at, or actually more than one. What is in this, trying to answer asked a question here, put it in terms, taking away that surface area that my well would need to feed water to it.
Yeah, sure. And I think that is answered in the report. If you go to specifically item 6, it talks about the fact that we're using municipal and sewer, municipal water and sewer, and that because of this, we should not or will not be impacting the bedrock aquifer wells because we're not taking away from that.
Well,
local water.
what I'm asking is you're taking away from the surface area that feeds my well just by the concrete and asphalt and the building area. I didn't see that in this report. Would that need to be taken into consideration?
In my opinion, no. I'm not honestly 100% sure of the question.
Yeah. Back to number 1, when you said no wells were within 100 feet, are you familiar with GW1 here in North Carolina?
Specifically, GW1, I'm not, but I'm assuming the person that wrote this report would be. And like, again, as I said earlier, any designs, we do need to follow the state, local, and federal regulations.
What were the setbacks again on this?
Setbacks the setbacks are 10 feet, and then the buffers are 20 feet.
So it would be approximately,
But again, the buildings themselves are set back about 50 feet off the property line. So we're past the 10 feet minimum
and then
requirements.
with that retaining wall back there too as well.
Yes.
How high was that retaining wall again?
Let me check the plans real quick. I think it's around 20 feet. Because our building is around 2160, and the top of wall roughly in that location would be 21, about 75, give or take. So between probably 15 and 20 feet.
No further questions.
Thank you. Any board questions for Mr. Tuddy?
May I have a brief redirect, Your Honor?
Yes, you may.
Okay. Mr. Tuddy, can you talk to the board about how stormwater is managed on the property and what the overall effect of stormwater plus or minus is based on the regulations that are in place?
So I can speak to kind of like the location of our stormwater. We do plan to send everything kind of south of us. We're planning on putting a primary SEM kind of south of our entry drive.
And can you explain what an SEM is?
Sorry, yes. It's a stormwater control measure. So it could be a pond, underground, detention. Basically, it's detaining the water on site. Really, one of the main goals of SEMs is to make sure that we are not sending more water off-site than, what was previously happening before the project comes online.
And you got the bad luck of me asking a confusing question, so let me ask a better one. Is part of the design of your system designed to capture the water that's on site and let it release slowly into the ground?
Yes, there are quality requirements when you design SEMs. So we do account for any type of pollutants or anything that might have more of because of the asphalt. That is all taken into account when we design our SEMs. We're collecting all the water from any asphalt on our site and some water not on our asphalt. So all that would be collected and sent to our pond.
So collected, filtered through natural processes, and released back into the ground.
That's correct.
Okay. So is it fair to say that as a result of that, there's not going to be an impact in the water table?
That is correct. Again, referencing the report, number 6 kind of, very clearly states that, we would not be impacting the aquifer.
And that is the point of all those regulations that you have to follow.
Yes, yeah. Again, groundwater, contamination, erosion control, those are huge hot button issues, both in North Carolina and just federally. There are a lot of regulations that kind of dictate what we are and are not allowed to do. And we would have to follow all those rules as we kind of designed this site and got approval through Buncombe County.
Yes?
No, Mr. Chair, thank you.
Board questions? Mr. Teddy? Yes, Joe?
Questions about the well. How many are going to be drilled?
So we do not have any wells on our site. We are connecting to the Weaverville water. So it would be connecting to like the city water.
Okay. Yeah, can you repeat that?
So our water and sewer is municipal. So it would be Weaverville water and then MSD for sewer.
No, but I'm talking about the wells.
Mhm.
How many wells will you be drilling?
We will not be drilling any
Joe,
wells.
No wells.
Joe, I think that, Joe, can you hear me?
Okay.
Joe?
Yeah.
So the water and sewage would already be installed in the initial phases of construction?
Yeah, none of the units would be able to come online until they had the water and sewer installed and released for use. We would not have any water wells or anything like that for our project.
So when would that take place during the phase of construction?
And to clarify, there's not going to be any wells drilled at all
Okay.
on this piece of property. No wells
Correct.
drilled at all. So there will be municipal water in a water pipe coming from Weaverville. And the sewage won't go into a septic system. It is going to be handled by MSD, the Metropolitan Sewerage District.
Okay, thank you.
Paul, do you have something or not? Yeah, okay, thank you. Mark?
Just one question, it's maybe a two-parter. You stated there would be a fence around the entire project.
Yes.
What kind of fence and what's the purpose?
The purpose is just to kind of, make sure the people entering and exiting the site. It's very typical for multi-family projects, just to keep, people out and just don't want people kind of walking across properties and things like that. And as far as the type, ultimately it would just be whatever the Buncombe County UDO requires.
Question, on the application, there's a question number 16 that deals with multi-level buildings shall be located in such a way as to dissipate any adverse impact on adjoining low-rise buildings. And so the response that was there says, it referenced the open use for the county and notes that the buildings on site will be set back 50 feet from the property line. Is that accurate? Are the buildings going to be set 50 feet back from the property line?
I believe roughly 50 feet. I would have to measure the exact measurements, but I believe it's roughly 50 feet. And, a lot of that has to do with grading. If you look at our site, it's a pretty steep site. And so we're kind of balancing the wall on the north side and the wall on the south side. And so, just from a site standpoint, we couldn't put the buildings right up on the property line, because if we did, then on the south side of the property line, we would end up with probably like a 40 or 50-foot wall, which we didn't want, so.
Okay, so on the north side, so the north side of the property slopes towards the south?
Correct, yes.
Okay, and so on that north side, the wall that you referenced would be a descending wall, or?
Yes, that's correct, yep. So it would be flowing down this way, the wall, and then it would continue down.
Okay, and then the fence, there would be a fence there? That's what I'm trying to figure out.
You would want to put a fence on the top of the wall too, just from like a safety standpoint.
Okay,
Yeah.
all right, that provides the explanation. Thank you.
Any other board questions? Hearing none, thank you so much, Mr. Tuddy.
Thank you, I appreciate
Take
it.
a quick 10-minute. Back to order, if you'll grab your seats. Moving forward with our hearing, we'll ask for the applicant to continue with any other witnesses they have.
We would call Mr. John Palmer.
Mr. John Palmer.
And Mr. Chair, while Mr. Palmer is making his way up, I have a resume for Mr. Palmer. It is attached to a very short affidavit. If it's okay with the board, I would like to present these just for the sake of efficiency for Mr. Palmer and for our next witness, Mr. Reinald Stevenson, who will be talking about traffic.
Sure.
And for Mr. Cody Tuddy. We've got copies and we can hand those up for
great.
everybody. All right, I apologize for not having that earlier.
Thank you.
Hello? Please raise your right hand and state your name.
John C. Palmer.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Okay, thank you.
Thank you.
Mr. Chair, I did not introduce Ashley Pierce from our office. She is a paralegal. She's an immense help. May she please approach the board to hand up this resume and affidavit
Please.
for Mr. Palmer.
Please and welcome. Thank you, Ashley.
Mr. Palmer, will you please introduce yourself to this board?
Yes, my name is John C. Palmer. I'm a commercial appraiser.
And can you tell me where you are employed?
I have my own company called the Palmer Company,
And how long have you had that company?
about 30 years now.
May I request that the meeting producer show what is on our laptop there?
Sure.
Here we go. There is a picture of Mr. Palmer, as if this board has not met Mr. Palmer on at least one occasion. Can you please describe to the board your education, training, and experience?
Yes, I attended Clemson University. I've been an appraiser, a commercial appraiser, licensed for 22 years. Is this on?
It
What
is.
is? I can't tell. Sorry. About 22 years now. I have three designations. I have an MAI designation for the Appraisal Institute, an AIGRS from the Appraisal Institute, and a CCIM from the Realtors Group.
And do you have experience in preparing market rate analysis studies for development projects?
Yes, I do market impact studies. Yes.
Thank you, Mr. Palmer. Can you explain to the board what that is?
A market impact study is, depending on your scope of work, is to try and see if there is a value difference in before and after is typically what it was before and after a project. You typically would use similar projects in an area in order to try to determine real estate values in that area.
Have you ever been recognized as an expert in that field before any board?
Yes.
Before this board?
Yes.
Can you give an estimate of how many times?
Quite a number. I've been here. I'm qualified in Superior Court, District Court, numerous county commissioner hearings, planning and zoning, things like that.
We have passed your CV to the board. Mr. Chair, at this time, we would ask that Mr. Palmer be tendered. We would ask that he be tendered as an expert in the field of market rate analysis and property valuation.
Any objection, Mr. McCurry? You all set? Board? Hearing objection, so admitted. Thank you.
We would also ask that his CV and affidavit be admitted into evidence.
So admitted. Thank you.
Right. Mr. Palmer, did you conduct a market rate study,
Impact.
a market impact analysis for this property?
Yes, I did.
Can you please explain to the board what that entailed?
I started with, I was supplied with the plans and specifications, and after looking at the project, going through it, I've got a data set of lots, almost all of the apartment complexes here, but also in a region area. From that, I developed a list of properties that I thought would be comparable, went through those, and then I pared it down to the ones that I thought were most applicable and similar to the proposed project.
What did you learn from conducting that study?
From conducting a study specifically for the site,
Yes.
there really was not any data that I found that would indicate there would be any kind of an impact on the value of the properties within the neighborhood in this instance.
Did you form an opinion as to whether this development would have a negative impact on the surrounding properties?
There was no indication that there would be.
Mr. Chair, those would be my questions for now.
Okay. Any cross for Mr. McCurry?
What did you use to come up with that there would be no surrounding impacts to the surrounding people's property values?
The comparables that I used, there's actually two that are affordable housing projects that I used for this, because this is an affordable housing project. What you would typically do is you would look to see sales and resales of properties is the way I do it. So you would look at to see when a property sold first, then you would see if it resold. The difference between the value will indicate whether there's an impact on the values.
So there was no definite impact then?
No.
Did the amount, did you take into consideration the AMI of the type of renters as far as income levels? Did that change any of the values of the properties? So I know this one is said to be 30 to 70 in the application. I think it said 60 to 100. I'd like a verification on that.
No, I didn't specifically look at that. What I did was I included in that data set two properties that were also low-income housing projects.
What were those AMIs?
The AMIs don't have anything to do with it.
No.
No.
That's all.
Thank you. Any from the board? More questions?
Just clarification, was there any report submitted as evidence?
We have not submitted a report. We have Mr. Palmer just here to answer any questions the board might have.
All right, thank you.
Any more questions at all on traffic? Evaluation, sorry. Okay. You don't see any. Thank you.
I believe the chair has guessed where we're going next. We would like to call our traffic engineering expert, Mr. Reinhold Stevens.
Thank you, Mr. Palmer.
Thank you. Thank you.
Stevenson, you said?
Please raise your right hand and state your name.
Reinhold Stevenson.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Okay, thank you.
Mr. Stevenson, can you please tell to the board your current employment and how long you've been there?
I am a traffic engineer with DRMP. I work out of the Raleigh office. I've been with the company or the same group of people in the company for over 25 years. I specialize in doing traffic studies for a variety of developments similar to this, and have worked on traffic studies for a wide range of projects all over the southeastern United States, but a lot of work in the North Carolina area.
And can you briefly describe your education, training, and your education and training?
Sure. I have a bachelor's degree and a master's degree in civil engineering from North Carolina State University. And as I've said, I've been practicing. I do have a professional engineering license in the state of North Carolina, and have been practicing for over 25 years.
Other than your professional engineering license, do you have any other certifications from the state as it relates to traffic?
No. I am qualified with the North Carolina Department of Transportation for traffic impact studies and various types of analyses that would be used for traffic studies.
And I believe in your CV, it mentions being pre-qualified for those things. Can you explain what that means?
The North Carolina Department of Transportation will review work that is submitted on behalf of an individual. So work that I have prepared is submitted to the North Carolina Department of Transportation. They review that, and if it is sufficient, they will qualify me as an expert or an engineer approved to do traffic engineering work.
Mr. Chair, this time we would tender Mr. Stevenson as an expert in traffic engineering and traffic impact analysis. I have his CV here that we can pass up as well.
Okay. Any objection, Mr. McCurry?
No.
Okay. Board? Thank you. So tendered. Thank you very much. And we'll go
May
ahead.
Ms. Pierce approach to,
Yes, and we'll go ahead and admit that as well.
and Mr. Chair, I believe you just said it, we are handing up Mr. Stevenson affidavit and resume. We would ask that they be admitted into the record.
So admitted?
So, Mr. Stevenson, this traffic impact analysis was provided to the county and as a part of this record. Can you give a brief overview to the board of what you did and what you learned?
Sure. So we did prepare a full traffic impact analysis for this project, and I will point out that the traffic study looked at specifically the 168 units that we're talking about today. But then we also looked at a future potential scenario for development of the rest of the property as a way to, in talking with NCDOT, they like to see what could potentially be developed around it. So we did make some assumptions about future potential development around these 168 units. And we start every traffic impact study by coordinating with the DOT, any local agencies, to discuss what needs to be included in the traffic study. So we call that scoping the traffic study. So we reached out, determined what intersections needed to go in, what time periods were important, all those things that go into the traffic study, and get that approved by the department, any local government, before we get too far into it. So we went through that process in working with them to get agreement upon all the assumptions and calculations in the study. Then we go forward and do a traffic counts and analysis of the intersections that are surrounding this property. And when we do that analysis, we look at things such as level of service of the intersections to determine when the development is completed and their traffic is added to the roads, what kind of impact does that have on level of service and delay at the intersections. So what we found with this is that there's relatively little change in levels of service and delay at the intersections surrounding the project. The intersection most of interest is where the site and development would access Old Mars Hill Highway, Silver Farm Road, and that is the intersection that we have discussed with NCDOT has been the most impacted and the one that we are going to be working very closely with them on for road improvements. But other than that intersection, the other intersections that are kind of upstream and downstream of the project had very little change in delay and level of service.
And Mr. Stevenson, for that one intersection, did you come up with something that could mitigate that?
Yeah, so what we looked at in our traffic study was the potential to provide a separate or exclusive left turn lane on Old Mars Hill Highway to allow the traffic that if you're coming from the interstate or coming from the south, you would be able to get into a left turn lane to be able to turn into this development from Old Mars Hill Highway.
And can you explain to the board who determines whether that lane can be installed?
And as part of the traffic study, we identified that as a potential improvement. NCDOT has looked at that, and they also think that that would be a reasonable improvement for that location. So what happens next is we enter into a more detailed design stage. And so there would be more detailed design done on that intersection to work out the very specifics of what the improvement looks like and how all of that actually would be laid out. But that's normally not done at a rezoning stage, and NCDOT agreed that we would be looking at that, in the future as more detailed design is done at the appropriate time.
And Mr. Stevenson, you picked up on exactly what I was going to say. Were you here to listen to staff introduce this project?
Yes.
As a recommended condition, staff said that there would have to be an NCDOT permit. Is that something that is related to the discussion you were just talking about?
Yes, yes. So what will happen is the development will ultimately need a driveway permit from NCDOT to legally access the roadways, the DOT roadways. So that driveway permit process will occur when more detailed design is done. And as part of that driveway permit approval process, the detailed designs for the intersection improvements will be done and will be reviewed by NCDOT, and the acceptable design will have to be approved by NCDOT in order for DOT to release or approve that driveway permit for us to be able to access their roadways.
Mr. Chair, those would be my questions for Mr. Stevenson.
Okay. Anything from Mr. McCray?
Yes. You stated there that the DOT in that one design, a left-hand turning lane, the Murphy Hill Road and the Old Mars Hill Highway section that goes into Kentwood Acres, that actually I call it Old Mars Hill Highway. How is that going to work again, especially with Murphy Hill Road? Would there be a red light there?
There would not be a signal there. What we've identified with NCDOT is that when you're coming up Old Mars Hill Highway to turn left into basically the access point into our project, we would be looking to provide or construct a left turn lane on Old Mars Hill Highway to be able to turn left into the driveway or access for this project.
You said DOT hasn't granted any access yet, because I know that property's landlocked.
The DOT has not granted any access at this point.
How long was the traffic study done, as far as that study?
I'm not sure.
I mean, the length of time the study.
It was, it's been done within the last few months.
Oh, I know, but I mean,
Right.
how many days? Was there ever another access discussed beyond that? Would it need more?
In talking with NCDOT, they were good with us studying the access coming off of what's Silverwood Farm.
So
Yep.
even future development, it would still be that one access?
At this point, that's what the study considers.
It did I guess this study did take into factor the 3 schools.
Yes, it did. Yes, sir.
As far as the study, I know you may not, how many cars did the apartment complex take into consideration?
How many did it generate?
Yeah, I
Yeah,
don't have that report in front of me.
Yeah, so there's a couple of things I'll say about that. One is the traffic study, or TIA, was done from a very conservative standpoint. And what I mean by that is we considered the 168 units to have more market rate type traffic patterns, which is typically higher than what affordable housing units would generate. So we have a little more traffic in our traffic study for these units than what is actually going to occur. But again, we were trying to be a little bit safer, with that in our numbers, to make sure our numbers are higher. So those numbers are, in the traffic study, the 168 units that would be more market rate type traffic patterns, which is higher than what's going to actually occur, would generate about 1 to 1.5 trips a minute in the heaviest hour of the day. So there's about 60 to 80 trips in 1 hour. It's the heaviest time of the day. You'll have about 1 to 1.5 trips per minute.
Did it take into also consideration of the commercial aspect of this?
It did.
It did take.
Yes, sir.
'Cause
It did. Yep.
I do know there was a daycare proposed, and it had in that study of 70 students in that, but
Yes,
it
sir.
only had, to me, a low number of cars. Only had 29 cars egressing for 70 kids. Are they all carpooling? or-
Well, what it is, the way the trip generation works is the traffic studies look at the heaviest hour of the day. So it's a 1 hour period. So even though there may be 70 kids there, the traffic that's used in the traffic study is the heaviest hour, the traffic that occurs in that heaviest hour. So that's not all day or not all afternoon or not all morning, it's the heaviest hour. So the highest hour, for trips coming to and from the daycare or from the residential units is what we're looking at.
When I read that, I didn't quite understand that.
Yeah, we're trying to look at we try to take we take traffic counts during rush hour, so the heaviest traffic time of the day. And then we also look at the trips that were generated by the development during the heaviest hour of the day. So we're looking at kind of I like to say, is sort of the highest of the highest, traffic time is what we're studying.
That's all I had on that as far as questions. Thank you.
Thank you. Any redirect?
No, Mr. Chair.
Thank you. Any board questions? Mr. Stevenson? Okay. Ina, thank you so much.
Unless the board has any questions for the witness we've presented so far, we would rest for now.
Sounds good. Mr. McCurry, do you have a case to present, or you may start your case if you'd like to.
As far as my standing goes, as far as the well water, I would still like to ask for a continuance based on the fact that in their report, Ray Holler Road was not mentioned. And also that the fact is that they said there would be no wells within 100 feet. There is wells within 100 feet, and I would like to have a professional, a third party come. I am able to do that and willing to do that if this board grants me a continuance. There was one question I failed to ask, but I can ask that possibly at a later date.
Now would be a time to do that.
Well, I was wanting to ask, as far as their civil engineer goes, I had a question about the grading. I did ask about the retaining wall. He did admit that that was a steep slope up there, and it is. And when you take that down and grade that down, you're going to expose. How deep are they planning on going? Because my well, one of my wells up there is 175 feet deep. It has a casing of 50 feet. They're going to hit rock pretty shallow. And they're also digging back in when they go down that slope. They're going to hit it. And I'm almost assuming they are going to have to blast. And is that blasting going to redirect our water up there on that hill? I would like to see the grading plans actually of that to see how deep this is going to go and what this is going to do, to be able to provide to my professional that I'll hire to do this, to be able to decide what aspects I'm going to have to do as far as what am I going to do about water if this dries up, if this dries my wells up, and my neighbors as well. But in that, I'm asking this board to grant me standing to be able to have a continuance to get a professional to do this. Thank you.
So the board's ruled on continuing the case once before, but we have had the benefit of hearing the applicant's case now. So I think just knowing that we've had the opportunity to hear from one side, the board may discuss and consider whether they would like to continue the case after hearing that. Yeah, it's fair.
Okay, can I just ask one question?
Yeah.
If we granted a continuance, would you attempt to argue that you don't want the development and that you want us to deny the application?
If the findings are, and this board, whatever the findings be and this board decides, I would have to live with that. Of course, I don't want it there. I'm afraid it's going to affect my wells and our neighbors' wells. But if whatever the finding is that a professional does, that I hire third party, whatever the finding is, it'll be this board's decision. It won't be mine.
I thought I had, Mr. Chair, was that the Kimley Horn representative, I believe it was Mr. Tuttle, was referencing a study that was not done by Mr. Tuttle, it was done by Jason Cheesley, and at times it was clear that he didn't own that report. He was referencing paragraphs, misrepresenting different paragraphs. And not that I don't appreciate Mr. Tuttle's testimony, but I don't know that having him speak to Mr. Sheasley's work is, that just
As
leaves.
useful as it could have been.
It could have been much more useful to respond to some of the questions. And I do think that the question of the grading plan, don't know, that was getting to my question of how high is this wall going to be and what kind of footings are now going to be in that wall, et cetera. So I'm sympathetic, but I'd like to hear the rest of my partners.
Yeah, sure. And the question is obviously on, we'll vote here in a minute, but on whether we should continue the case to next hearing to give Mr. McCurry time to procure his professionals. We voted before on whether we should continue it, but now we had the opportunity to hear from one side's case, and if that changes any views up here.
I haven't heard anything that made me feel any differently. I mean, it's an unfortunate situation, and I don't know what delayed his reaction time to deciding, whenever that, I can't get this done. And I think we heard he's known about this since September. Is that correct? September?
When they first started, yes.
September. I mean, my God, that's been months.
In January, if there's going to be a case.
I mean, having done some of the professional studies and reports he's talking about, in my opinion, it won't be done in a month. It may not be done in 3. I've done a lot of that. And I certainly have some compassion for his situation, but I don't know that the folks asking for this should bear the burden of this. This is a fantastically expensive show to put on. The gentleman's been aware that this was coming down the pipeline. And all of that being said, I still haven't heard anything, assuming that he was a professional, that I would say raises me to the standard of he's uniquely injured.
Okay. Other thoughts? Joel, do you have anything? No, you haven't, okay.
Just, if we did grant a continuance, could you just sort of briefly say what would be the impact of, maybe would it greatly slow down the project, or?
Yes, so a few things. To answer that question, yes, there are funding deadlines that must be met. This is an affordable housing development. We are up against the wire to getting our federal applications in and state applications in to get that funding. So it is important that we get our entitlements in a timely manner. I do want to, in talking about whether this needs to be continued, I want to try and give some comfort about what's going on here. So this is just an entitlement for a site plan that can be changed to some extent. And, if it has to be changed to a larger extent, we'll have to come back to this board. But if we run into things on the ground that make something impossible to do because it would impact somebody else, you'll see us back here. So the first thing that comes to mind is a grading permit. The Building and Permits and Inspections Department is going to require us to get a grading permit. We don't have a grading plan to show right now. It's too early in the process. But we know that a grading permit will have to be issued by the Permits and Inspections Department. And if there's, for some reason, it won't work, we'll be back in front of this board asking to do something else. The second thing is a retaining wall permit. That is, the Permits and Inspection Department has a specific permit that you have to pull for retaining walls over a certain height. Not only that, it's going to have to be engineered. So there's going to be a lot of work put into getting these retaining walls done, getting the grading done, and it's a process that happens outside of this process. So the thing that he's asking for a continuance for isn't something that we'd be addressing at the next session either. And again, yes, there are time pressures here from our side on the affordable housing side. We do need to keep on our schedule.
Okay.
Let me throw this, I've been thinking about this, throw this out there on the table, Mr. Freeman, for the developer to consider. There is Weaverville water all around these properties, correct?
Yes, sir.
I mean, it is, I dare to throw this out there because well impacts are very subjective as far as that goes, but would the developer be willing to, if there is a direct impact to his wells as a result of this project, provide connectivity to the town of Weaverville water to solve the problem? If it were, this is an if scenario, right? Because there is a solvable problem here.
I'm happy to have that conversation. I can have it right now if the board would like for me to.
Is Mr. McCurry interested in that conversation as far as a connection to city waters through?
This would be only if. My suggestion is
This
only
is hypothetical, yeah.
Hypothetical.
Yeah.
This is a hypothetical.
I'll listen to it, but.
Okay, listen to it, yeah, okay. Do you have the conversation? Let's get a 5-minute, real quick, for that conversation to occur. What are results of that conversation?
So the spirit of the answer is, sure, absolutely, we would do that. The caveat is to the extent that it's feasible. So there's obviously another big player here. That's the town of Weaverville. And, you know, they would have to go through their allocation process, those things. But yes, we are willing to, if there is a need, maybe even a desire to have that conversation, how do we make it super easy for us to stub some water to you and you be able to get it? Now, that said, it's not always super easy just to stub water there. So we really can't, commit to something that we haven't had laid out. But I also want to say
That would be
this.
on the condition that Weaverville extended water and, yeah.
Yeah, so it's extended to it's extended to the site,
Yeah.
right? So they're going to bring the site from where Weaverville, gets it to their site, provides it to the site. I'm not sure, Mr. McCurry's property is behind ours. I don't know what Weaverville requires as far as their water lines following rights of way and utilities rights of way. I just don't know. If it were as simple as me saying, oh, we could just, run, a couple 100 feet of pipe and stub it, on his property and that's sufficient, I just don't know if that's the case. I will say this, though. As we have presented here today, we are confident from our engineers, from state laws regulating this, from state laws that apply to grading and the retaining walls, that it's not going to impact the wells. So if it did, I think that, I'd be worried from, the hat that I wear the other time as being an attorney, as, an attorney who's worried about, some sort of, personal injury or injury to property claim. Like, it's just not something that we're interested in doing, is impacting his ability to use his well. We just don't see that in the cards. But that said, we're willing to have the conversation about, how do we be a good neighbor? And now that we're paying the bulk fee to get water to that area from Weaverville, how do we make it available to other people if they want it?
What are the board's thoughts on that? Do you want to, follow up or?
I think that's probably the best they can offer at this point, because there is a third party
Yeah.
to this none of us have control in this room for.
It would be hard to write that kind of condition up, contingent on Weaverville's, yeah, it would be hard. Okay. All right, so we are in the process, still in Mr. McCurry's. Yeah, we need a motion, yeah. So we need a motion on whether or not to continue the hearing, yeah. It could be a declination motion if that's the feeling, so.
Chair, bring forth a motion to not accept the request to continue
Okay.
tonight.
Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? That passes, so we'll continue on today. Do we have any more witnesses to present, Mr. McCurry?
Nah, I don't have anything else.
Okay, all right.
I don't know if any of the people that's here has anything.
Okay. Any cross for that, Mr.
No,
Freeman?
Mr. Chair.
Okay. Before we move to closing statements, let's go ahead and have a witness testimony period. If you are here to speak on this application for or against, if you will raise your hand, that'd be great. We don't have a preset list, is that right, Griffin?
There were, I believe, 2 individuals who did submit
Okay.
forms in advance.
Those were?
Pam McCurry and Jeffrey Brian Wett.
Is Ms. McCurry here? Does she wish to say anything? Yes, ma'am. You come on up. Yeah, sure. I'll have you speak into the microphone, and we'll swear you in as well.
I'm Pam McCurry.
Please raise your right hand and state your name.
Pam McCurry.
Do you swear to tell the whole truth and nothing but the truth?
Yes, ma'am.
Thank you.
So.
Welcome again.
I'm Pam McCurry. Keith is my husband, so I have the same issues that he has, obviously. Our concern is the water. I mean, I know possibility, but that's not guaranteed. So even if I don't like living there and this comes in and I decide to sell, we can't sell property without water. I mean, everybody knows that. My family's been there. My papa bought that land in 1944. So we've been there for 5 generations. I know that's getting less and less in Buncombe County in every area, and a lot of people don't care. But I have an attachment to the land, as my whole family does. And we hate seeing the stuff come in, but we know progress, you can't stop progress. But I do wish that Buncombe County would start taking in consideration certain locations for these big complexes and not put them so far out in the county. I think there are places that they could go. They need to stay in closer to town municipalities and within the cities and not disrupt our rural communities as much. I really wish Buncombe County would consider that. And the other thing on that is when these come in and they're affordable housing, most of those are tax exempt. And a lot of us just got hit with a tax increase that's coming. We know it's coming. So our taxes go up and they get exempt. That's hard to swallow. And it gets to the point then ours goes up so much, my children can't afford to live here. So they're looking elsewhere to get out of Buncombe County because we're getting so much into Buncombe County. The growth is so expanded, and I think it's so fast, we just can't keep up with it anymore. And people like me and my family are just being washed to the side. I mean, I just don't think Buncombe cares about the citizens that have been here for a long time. I think it's the tax money and the revenue that's coming in. And the developers that have all the experts have more say than the citizens that have been here for years. It's all the new people. I don't think that we matter much anymore. So I don't think it's really done us much good to be here except for learning. We've learned a lot through this process. We learned a lot going through Weaverville. Don't know that it's helped us any, in all honesty. But other than that, I mean, like I said, progress is going to come and you're not going to stop it. But I really wish that y'all would start considering having sewer and septic on the properties before allowing something like this to come in, to where you're not having to look at probably, I'm hearing some of the sewer might be eminent domain on some people's properties because sewer is nowhere near this property. It's going to be over 2 miles long, if not longer. You're going to have to come across people. We're going to have to put pump stations in. That's going to take people's property. I don't think that's right. If you want this stuff, put it where this infrastructure is already there, or we know it's coming in future, but let the infrastructure come first and let it be there. That way people know when you buy a property, it's there. And you know you might have the opportunity of something that's coming in because the infrastructure is already there. I mean, I've told my husband, I'm ready to get out. But the problem is, where do we go that we don't have this? Where can we go in Buncombe County and afford anything? And Madison's about getting the same way. I mean, you've got so many people coming into these southern states. It's growing so fast. I think we're going to outgrow more than what we can really intake and sustain. I think there's going to be a time. It's going to be. Helene was bad for us. I hope to never see nothing like that again. But in my opinion, you're letting so many developers in here with these big projects. I don't say it's nowhere near Helene because it's not. But to me, it kind of feels like that. So I just wish you would just really look when these big projects come in, or maybe regulating them just a little bit more of where they can go and not upset the communities as much. That's pretty much it. Thank you.
Thanks for being here. Thanks for your comments.
Thank you.
And Jeffrey, I didn't get your last name, I'm sorry. Please come on. Yeah, please come forward. We'll start by swearing in, and we'll ask you to speak in the microphone.
Please raise your right hand and state your name.
Jeffrey Brian Witt.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, sir.
Thank you for hearing me. So, I'm a 40-year resident of this property. I grew up there and lived there. Chose to bring my family out of the city or of Weaverville. We lived there for a small period of time and build there because we like the more rural side of it. Really enjoy the area, really enjoyed growing up in Buncombe County. A lot of the points that I had to make have already been established. I went through and looked at the burden of proof and kind of thought about like, okay, well, how much different is the development than the zoning the way that it's rated now? And I mean, there's some significant differences. You know, there's gonna be more light saturation to my property, which, you know, for somebody that likes seeing the stars and stuff at night, it's nice. It's dark at my house. You know, I don't live in the city, and that's part of what I enjoy about it, you know, that it's dark in my house. The noise, there's gonna, I would estimate 400 more families in this space, so roughly around 500 families will be living here instead of 100. You know, so the noise is going to be, you know, greater. The odor, it says, you know, where it may not be as bad, but all the trash cans on their plans, you know, all the dumpster sites are kind of located right at, you know, right next, basically as close to places where people live, you know. How would you feel if a dumpster like that was put right up against your place, you know? And so that's the main things to me, is just that it goes above and beyond what I thought was going to be there whenever I spent every penny I had to build the house that I've got, you know, and it leaves me with my choice. Well, if I don't want to live next to that now, I have to sell and move from someplace that I've been my whole life, you know. And so, you know, just kind of thinking about the well thing, you know, like, we're not experts. I work with trees. And, you know, Keith is a diesel mechanic. We're not an expert on this. Like, we kind of really rely on y'all to, like, tell us. We didn't know really until, like, in the last week we really started talking about, like, well, maybe we need to hire an expert. There's not an easy way for an individual or a resident to just, you know, find that. It's not on your website and not openly available. I just don't know, you know, what the options are and what the thoughts are, but that's really what I had, and I appreciate you guys listening to me. Thank you.
Thanks for being here. Thanks for the comments. Anyone else here to speak for or against this matter? Going twice. Third call. Yes, ma'am. And both of you can approach if you want to. You can speak one at a time. Yeah. And we'll swear you in first, and then we'll ask you to speak into the microphone.
Okay, sir, please raise your right hand and state your name.
Billy Stowe.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes, I do.
Thank you.
Welcome, sir.
The biggest concern, well, a couple concerns. I think we've already chased the well around about all we can right now. Well, I do have a well. I live in the Kentwood Acres subdivision, a small subdivision that feeds into. Now, we've got like 35 houses in there, and they're all on well. Not any high-producing wells in there by any means. It's called Dry Ridge for a reason, but another big concern is the traffic, and I know we addressed it. We come into that Mars Hill Highway from, I guess it's referred to now as old Mars Hill Highway. It feeds in right below the entrance ramp to 1923 coming this way. Then the turning lane, it's putting a Band-Aid on a pretty big wound, I think, because they can't be very long, because if it's a very long turning lane, left turn lane, it's going to come up to where the entrance is to the entrance ramps to 1923 or 26. So it can back traffic up. I've seen it back up there without a left turn lane anyway, you know, with the high school and the middle school. There's like 4 schools that feeds that road within 2 miles of either direction that you go. But there's times of the day you can just grit your teeth and hold on when you come out there, because it'll back up past where we come into it, which will be 6 or 8 cars will be backed up coming on through that entrance ramp now, at certain times of the day. And it's a big mess. And it is school time. There's a lot of school traffic, but there's a lot of local traffic in there too. And that's the biggest concern we got is the left turn lane he's talking about. I know that they've done studies that will help, but I don't think that's going to solve a problem that is absolutely going to happen. And that's really about the biggest concerns we got. I thank you for your time.
Thanks for being here. Thanks for your comments. Anyone else to speak on this matter? Yes, ma'am. Let's make sure you cover it all. Yeah. Make sure you cover it all. Yeah.
All right, please raise your right hand and state your name.
Phyllis Stowe.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Okay, thank you.
Thank you.
I know my husband just talked about the traffic. We were concerned about the traffic, but I hate to bring this up again, but I am concerned about the well. Because we live on the ridge that we've been talking about that abuts this development, this new development. And I'm concerned, this is the first time I've heard about all the grading that they're going to have to do along that ridge, and that's where I'm concerned about the water level, that I'm afraid it might disturb the water level. We have lived in that Kentwood Acres for 37 years, and we have asked, when we built the house, if Weaverville would take us in and give us water. And the water line was running right down at the end of the road, but they would not do that. And so, of course, we had to drill a well. Well, our first well is 550 feet, and it's dry. And then our second well, we drilled, and it's 324 feet, and we get 3 gallons a minute. So I'm not sure if when you grade, if that's going to disturb some of the water tables that's there, that it will decrease our water. And we can't afford to put another 500-foot well and get no water. And so I would just like maybe the continuance that Mr. McCurry asked for. I thought I would have liked that to have been considered for that reason. So, but I appreciate it.
Thank you so much, ma'am, for being here. Anyone else speak as a witness today? All right, thank you very much. We'll ask both parties if you care to submit a closing remarks. Mr. McCurry, care for anything to submit any closing remarks?
Again, I do want to thank this board for allowing me to speak today. I appreciate the opportunity to do this. Again, this is new to me, as my wife said. This is the first time we've really been politically active for my whole life, other than listening to Rush Limbaugh and Glenn Beck on the radio. That's about as active as I get. So I do appreciate this, and I have learned a lot. But as my wife said, we've lived here. I've lived in Buncombe County all of my life. Went to Inca High School and graduated there, and moved to Weaverville in '92. And when me and my wife got married, she moved me back to Weaverville. She wouldn't allow me to live in Inca no more. So, but anyway, I do love living there. I don't want to see this type of development in these areas. As my wife stated, I think they are areas for these developments, and I don't think it's out in these rural areas like this when it's surrounded by so many homes. It changes the landscape. It changes the community as a whole when you move in those many families like that. Again, my concerns were with the water, and I know there's no continuance. That's y'all's decision, and I respect that. But there is more to come, I know, on this. The grading, all of this stuff that will be taking place, they'll have to get their permits, and there's still a process to go. I do want to say the utilities, I do agree with what my wife said. I think these utilities need to be in place before these developments go in, water and sewer. And just like she said, the sewer is not there. It's got to be run nearly 2 miles. And those Easements have, far as I know, have not been obtained yet. And some of our community members who could not be here today, they have been approached and they have been told if they don't comply, they'll just take it by eminent domain. So I don't agree with that. Eminent domain for a private developer is, in my book, that's wrong. So again, I do thank this board for that. Thank for listening to all of these others here and give us our concerns. And I do appreciate your time. Thank you.
Thank you so much. Mr. Freeman.
I'll be very brief. I heard the witnesses who spoke today. You know, I'm from here as well. I get the concerns that are raised. I also want to say loudly for folks to hear that a lot of the things that have been, you know, requested here are outside of this board's purview. And the board is probably not going to get in a soapbox and tell people that, but the board is limited to looking at the standards that are in the zoning ordinance and determining whether an applicant has met the standards in that ordinance. It's a tough job, and it requires putting on a judicial hat and looking at the evidence that was presented and weighing it against those ordinances. So I hope that no one in the audience, you know, holds that against the board. We certainly don't hold it against the board for holding us to our burden. We believe that we have met every element that is required for the issuance of a special use permit. We've had experts come and speak to each one of those details. There has been no competent material evidence raised against that, and I think it makes the job of this board pretty clear for the issuance of the permit. We respectfully request that the permit be issued, and we will follow all appropriate steps as far as getting the appropriate permits from North Carolina Department of Transportation, getting those appropriate permits from the Building and Inspections Department. And we thank you all for your service in the Board of Adjustment.
Thank you. At this time, we'll close the public hearing and open up for board discussions, deliberation. Please, Joel.
Yeah, first, to the witnesses, let me suggest something. Planning and zoning for the county are reviewing ordinances. And I would suggest you got concerns, contact the county commission. The other thing, to the applicant, I'm willing to support your request if you put a condition in it regarding if the people surrounding landowners suffer any water resource damage, that you basically take action. I'm confident as a landowner in the county, I get Weaverville water. And I've learned from other people in development, so forth, if you build it, the water will come. So, you know, if you're willing to put a condition to ensure there's no damage with surrounding water systems, their wells, then I would support your application.
Let's wait on that response until we go around the horn, yeah? Anyone else to speak?
Yeah, I haven't heard any significant reason not to grant the request. I think Joel's point is an interesting one. You know, the exact phrasing of that would be, you know, interesting to hear, but I don't think it's a bad idea to consider it.
I tend to agree with Paul in terms of the applicant has put forth a case where they've checked all the boxes. They've thought through all of the responses. I also think that they've applied the due diligence to ensure that if something does go wrong, it's very clear that they have been responding to potentialities of what might go wrong. And it isn't like it would be a surprise. It has been clearly articulated. The concern is about the water. And I think that as professionals, they're going to hire professionals, and those professionals are going to ensure that that scenario doesn't come to pass. And we have the planning folks here in the county that will ensure as best they can that those scenarios will not come to pass. And so combining with, in fact, the quality of the applicant's case, I support.
I would agree with those, with the majority of those comments, and just say that the applicant has proved met their burden, and we've heard a good presentation. I also am wary, as a lot of members of the public here have expressed, about extending high-density development further into rural areas in the county. That's always a concern for planning department, for the commission, and that's appropriate avenue for that, of course, through the planning commission and through the commissioners. But I would say for an affordable housing project is, one of the number one needs in the county that we have, certainly top three needs. And so I think that's an overriding factor here. And I also have not heard of a whole lot of instances where you bring in a complex using municipal water, and that would affect the water table so much that you would have impacts on local wells. So I haven't seen any evidence that is directly correlated as a problem. So I wouldn't worry as much as maybe some worries been expressed today. That's just my thoughts.
I think I agree.
Yeah.
Yeah.
I agree. I mean, I do sympathize with the statements of the witnesses. I think it's very important, those concerns. Water's a precious resource, but at the same time, we are bound by the standards, and I see no reason that it would not be granted.
Mr. Chair?
Yes.
Based upon the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presented at the hearing, and unless I hear anything else, I believe that would be all-inclusive. I move that this board adopt the following findings of fact. 1, that this matter was properly advertised, is within this board's jurisdiction, and is ripe for its consideration. 2, that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in the Buncombe County Code of Ordinances, Section 78-621, subparagraph 3.
There's been a motion. On findings of fact, is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? That passes.
Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There's been an approval motion. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? That's 6-1, that passes. Thank you so much. I will ask if staff has a copy of an order for us to consider today.
Yes,
This
Mr.
matter.
Chair, I've drafted an order which I will review for the board right now. Dispensing with the caption, "This matter having come on for hearing before the Buncombe County Board of Adjustment at today's meeting upon application to establish a planned unit development for a 168-unit multifamily residential development on behalf of Chris Dischinger of LDG Multifamily LLC applicant and Reese Lasher of Weaver Vegas LLC. Having considered the evidence presented to this board, including the application, the submitted development plans, the GIS maps, the staff report, the applicant's affidavits, the testimony presented, and the arguments advanced by the parties, the board hereby finds as follows. Findings of fact. 1, this matter was properly noticed and advertised, is within the board's jurisdiction, and is ripe for its consideration. 2, that the applicant filed for an SUP pursuant to the zoning ordinance of Buncombe County to establish a planned unit development, 1, for a 168-unit multifamily residential development at 10 Silverwood Farm Road. Property is located in an open-use zoning district. 4th, that at the hearing, the applicant and any parties withstanding were given the opportunity to offer oral and documentary evidence, as well as to submit questions to each other, county staff, and board members. 5th, that pursuant to Buncombe County Code of Ordinances, the board finds as follows regarding the special use proposed in the application. 5A, PUDI standards. 1, that the land within the PUD will be under single ownership or management by the applicant before final approval, and/or construction or proper assurances have been provided such that the development can be successfully completed by the applicant. 5.2, that the density is consistent with the intent of the district in which it is located and conforms to that permit in the district in which the development is located. 3, that the land uses are compatible with and do not violate the intent of the zoning district and do not disrupt the character of the community. 4th, that the proposed land use meets minimum requirements for land development as follows. The minimum lot size and requirements for interior setbacks do preserve the spirit and intent of this section and does comply with the density requirements for the zoning district with respect to total development plan. Proposed heights as set forth in the application comply with the spirit and intent of this section with respect to the total development plan. Where building heights exceed maximums allowed by ordinance, this board finds that unique elements of the development impose requirements for additional height that are not universal throughout the zoning district. This board finds that the minimum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles. That the development does provide reasonable visual and acoustical privacy for all dwelling units. Fences, insulation, walks, barriers, and landscaping will be used for the production and aesthetic enhancement of property and the privacy of its occupants, screening of objectionable views or uses, and reduction of noise. Multi-level buildings are located in such a way as to dissipate any adverse impact on adjoining low-rise buildings and do not invade the privacy of the occupants of such low-rise buildings. That the structures located on the perimeter of the development will be set back from property lines and rights-of-way abutting streets in accordance with the provisions of the zoning ordinance controlling the district. This board finds that the proposed parking does comply with the spirit and intent of this section. As applicable, this board finds that the conveyance and maintenance of open space, recreational areas, and communally owned facilities are in accordance with the law, the Unit Ownership Act, and or any other appropriate mechanisms as specified. This board finds that the building envelopes are shown in the submitted plans and depict the maximum expanse of the proposed footprint of the structure. That pursuant to the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for at least the following as it relates to the proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood. The proposed use will not be detrimental to the public welfare or injurious to property or public improvements in the neighborhood. The proposed use will not cause or have adverse effects on surrounding properties due to noise, vibration, odor, or glare effects. Satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided. Particular attention has been paid to the automotive and pedestrian safety and convenience, traffic flow, and control. Provision of off-street parking and loading areas where required, with particular attention to items in 78-658 of the Buncombe County zoning ordinance, have been arranged for. Provisions for adequate and proper utilities with reference to locations, availability, and compatibility have been arranged for. Is the board comfortable with that, given the statements that were made about the sewerage and water?
I believe so.
Okay.
Yeah.
Provisions of buffering, if deemed necessary, with reference to type, location, and dimensions have been arranged for. Oops. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways with reference to location, size, and suitability have been arranged for. Buildings and structures with reference to location, size, and use are acceptable. Hours of operation with particular reference to protecting and maintaining the character of the neighborhood are acceptable. The following conditions are necessary to ensure that the proposed use will conform to the requirements and spirit of the Buncombe County Zone Ordinance. 1, the applicant must coordinate with MSD to meet requirements of off-site easement acquisition, pump station and force main alignment approval, gravity sewer plan approval, and fully executed DOT encroachment. 2, the project must be constructed as depicted in the site plan. 3, prior to commencement of land disturbance and construction activity, the applicant shall submit a site plan development permit for the entire project, indicating the following information: the exact location of all buildings and accessory structures, commercial lighting plan, buffer landscaping and parking lot landscaping, retaining walls, easements and rights of way, approve E911 road names, and any other conditions of site development approved by the Board of Adjustment, a copy of approved permits from the U.S. Army Corps of Engineers, the North Carolina Department of Transportation, and the North Carolina Department of Environmental Quality where applicable. This master site plan approval shall not replace the requirement of pulling an individual site plan permit for each building or structure within the development. The applicant must agree in writing to these conditions prior to the commencement of site work. Based on the foregoing findings of fact, this board makes the following conclusions of law. The applicant's request for a special use permit, together with the imposition of conditions found necessary above, which are incorporated herein as is fully set forth, meets each applicable requirement of the Buncombe County zoning ordinance. Now, therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders as follows: that the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions referenced above, which are incorporated as if fully set forth herein, the 8th day of April 2026.
Move to accept.
There's a motion on the order. Is there a second?
Second.
All those in favor, please say aye. Aye. Any opposed? Nay. Thank you. That passes. Thank you very much. That is approved. We'll take a 5-minute before we start the next case. Okay, we are back. ZPH 2025
I got it.
00038, the Carroll at Sweeten Creek, special use permit. And if you want to present?
Certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objection, so admitted.
This is a review of ZPH 2025-00038 Carroll at Sweeten Creek. Applicant is Warren Sugg of Civil Design Concepts, located at 99999 Sweeten Creek Road. The total acreage is 26 acres. Development is served by public water and sewer. It's zoned R2 and is within the Blue Ridge Parkway overlay. Special use permit is for the development of 305 apartment units across 9 structures. No deviations are requested. If approved by the board, staff recommends the following conditions of approval, which I will summarize. Applicant must agree to permit post-construction stormwater conveyance and treatment of the stormwater generated by the secondary access through the city of Asheville. All other stormwater permitting is to be handled by Buncombe County. The submitted view shed analysis must be adhered to for compliance with Blue Ridge Parkway overlay requirements. Project must be constructed as depicted in site plan. Prior to commencement of land disturbance and construction, the applicant shall submit a site plan review permit for the entire project. Applicant must agree in writing to these conditions prior to commencement of site work.
All right. Any questions for staff on this project? Hearing none, thank you very much. Anyone here to assert standing on this matter? Any standing applications? And keep in mind, we have a witness portion later on in the process where we'll hear from witnesses for or against a project. But if you want to be a part of the hearing and assert standing, the board has to approve that. We have 2 raised hands, is that right? And Griffin, which one was the first on our list?
It's Adam Sumer.
Thanks. Adam, are you here? I'm here. Thanks, sir. We'll have you sworn in and we'll speak into the mic.
Okay.
My name is Adam Sumir.
Please raise your right hand and state your name.
Adam Sumir.
Okay. Do you swear and affirm to tell the truth and nothing but the truth?
I do, yes.
Okay, thank you.
Welcome, sir.
Thank you. I appreciate it. I was really ready to go this morning after 5 cups of coffee, but I'm trying to wake up after sitting here for 3 hours. Are any of you familiar with this site, where it stands?
We are. We've got the application
You
materials
have?
here.
Okay, I just wanted you to be aware that this is actually on a hilltop, which is 2,500 feet in elevation. And I have 3 points that I would like to make. So first of all, our property.
So before we get into details, I'm sorry to interrupt, but we want to talk about in this particular part
Oh,
of
it
the hearing.
affects me, correct?
Why you would qualify for standing.
Sure.
So reasons your property is impacted individually among other properties.
And I'm going to lead up to that, correct?
Sure.
So this property is an elevated construction site on the hilltop. We have an old family farm, 50 acres, just south of the property, which is about 300 feet below the property. It's very steep. I actually flew in here last night. I walked it because it's been a long time since I've been up there. It is a very steep slope, over 50% below where the subject property is being built. So I have 3 major concerns. One is the stormwater runoff. And I'll read to you what I wrote this morning. And let me tell you this, stormwater runoff is number 1 because of the elevation and the site grade. Number 2 is the slope integrity of where they're proposing to build. And number 3 is the Blue Ridge overlay and the Asheville scenic view. As I mentioned earlier, this is on a hilltop which is viewable and you can see through Hendersonville Road, downtown Asheville, and the Blue Ridge Parkway. So this is a hilltop and a scenic preserve that is being compromised. Number 1, major concern, and I want to fast forward really quick, just tell you a 1-minute story. We have 200 acres in Waynesville. We had a builder just like this tell us everything was okay. I had a cousin go listen to the meeting. And this is only a 10% grade. They site prepped 20 acres. And of those 20 acres, when they were site prepped, the water was put into one spot where it drained onto our property, and 20 to 30 acres have now been compromised. Fast forward, we are in a lawsuit with the builder, and I've had to hire engineers to testify in a future lawsuit. So I'm aware now what I didn't think was a big issue, but stormwater runoff is a very important and big issue when it comes to development, especially one of this slope. Stormwater runoff, this development will significantly increase stormwater runoff toward lower properties. This is a high-density project on steep terrain above existing homes, including ours. It creates real downstream risk. I asked the board to ensure strict compliance. I am just now finding out about this project 1 week ago. From my previous experience in Waynesville, from when I found out about what was happening, retaining legal counsel, hiring engineering to do the reports, has taken me about 4 or 5 months. And I noticed earlier a guy had like a 1-month window. I will not have engineering reports by next month. It will probably take me 4 or 5 months to prepare all this information. I do plan on getting legal counsel, and I do plan on hiring the same engineer in Waynesville as this property. Number 2, the slope. As I mentioned earlier, and the board is aware, this is on a hilltop. I don't know what the rules or regulations are for a hilltop that's 2,500 feet in elevation, but this hill can be seen in Asheville, on Hendersonville Road, and more importantly, the Blue Ridge Parkway. And I'll get to that soon. When I say that this is steep terrain, the area that they are proposing to build 2 apartment complexes at the steepest part of the hill, below where our property is notorious for groundwater runoff and erosion. Of our entire property, that's where all the trees fall whenever there's a large amount of water. So I'm a little nervous that not having maintained an area below where they're building 2 apartment complexes will somehow, I don't know, affect it. Also, the grade of this project is very concerning. There are areas that on this hill are 30 to 50% grade, if I'm not mistaken. I'll have to get my engineer to verify that. And I can tell you below that, I measured an aerial view. It's 100 feet from our property line to their property line, and you're going up about 100 to 150 feet. And I would say it's at least 50 feet in elevation, because I walked it yesterday, and it was steep terrain. So that's my second concern, is the slope integrity. I don't know if any geotechnical plans were made to ensure that the slope integrity will remain intact once they start site prepping this construction site. And number 3, which I think should be concerning to, and this is how it impacts my lot specifically, our property specifically. Would you like for me to go into how I feel it affects me and including other residences as well?
I would like you to go into the first part of that without other residences included. So this is all about how your property individually is affected, separate and apart from others.
Okay.
Things that don't include how other properties are affected.
Well, my next was going to be the Blue Ridge overlay of Asheville. Would you like for me to include that now or later?
If it's pertaining to how you're affected, no, it's a zoning district, so it would affect other properties too. So things that only affect your property.
Okay, so stormwater runoff is the major concern. Well, we've been, our land has been compromised by other developments in other parts of the state. And this is a family property that we cherish a lot. And I would like to have the time to get my own engineering report, and I would like the time to get legal counsel. That way we can defend ourselves here and ensure that the board is complying, that the developers are complying with everything within the scope of work that the board has to approve.
Just looking at the GIS map, can you describe just basically where you are, where your property is in comparison to the subject property?
Is there something I can look at on?
Can we pull it up on the screen? GIS map. It's linked to the
You can pull up
application
175 Round Top Road if that helps. Next presentation, I'll have a laptop connected with visuals and handouts.
It'll be all fancy next time.
And everything, yeah, no,
Yeah.
I was not aware.
No, you're fine, yeah.
Look like. Wasn't this guy here for the last one? Is he doing both?
He's a popular guy, yeah,
Okay.
yeah.
Handing out cards here.
Just briefly, you're on the north end of the property, or?
I'll show you.
Okay, you'll show me.
Ours extends,
Yeah, he's north. I can help us go.
Okay.
we are north of the property, yes.
Got it.
So our property extends from Sweeten Creek Road to Round Top Road. I can see it here, yeah. So this is the subject property. This is Biltmore. That little dot that you see where it says 2,500 feet, that's the highest point of the hill. Is there a way to get an aerial view on here? Can I get an aerial view, please? Thank you. So if you look at the construction proposal, the site plan that was prepared by Mr. Suggs, this is our property, and this is our property here also in front. This is the main house. Where the cursor is where two apartment complexes are proposing to be built. Just south of this is a very steep ridge line that I hiked yesterday just to remind myself how steep it is. That water drainage and runoff is what scares me the most, because this slope is directed right towards our house. And I don't see anything in this construction site or the plans that take into account, number one, the integrity of the slope below the property line to our house, or anything about water runoff and how in a rainfall that would affect our property and which direction this stuff is going. I'd like to have an engineer, hire an engineer again to do a report, look at his study and see what he thinks about this.
Is this the Barry Summer property?
Barry is my aunt, Sumir is my mother, yes.
Mayor, sorry. Thank you.
While you're on that subject,
Yes.
I did note, actually Savannah noted that this is owned by a revocable trust.
It is.
Are you a beneficiary of the trust?
I'm the son.
Okay.
I believe I am, yes.
So that makes this kind of difficult because technically,
I am a
Mr.
beneficiary of the trust.
Mr.
yes.
Samir is not the owner of the property. So he'd be acting basically as counsel for the owner of the property, which is the revocable trust.
Did you sign that you're a member of the trust, or not, or are you just a beneficiary?
I can tell you my aunt and my mother own it. My sister and I and her and my aunt's daughter are the
Heirs, yeah.
We are the heirs and mentioned in the trust
Okay.
as part ownership, so I would say that would qualify, correct?
So he's not currently an owner. He will be an owner in the.
Right.
Well, the trust will always be the owner. He'll be a beneficiary, and then they'll do what they want with the revocable trust. So my preference is that
Yeah.
that is represented by counsel for the trust. But that'll be up to the board to determine if it's comfortable with Mr. Sumer.
Right, or a member manager of the trust.
Member manager of the trust.
So, and that would be if the board grants standing to that entity.
Yes.
In absentia for next month.
Yes,
Okay.
that's correct.
So one of them would, if the attorney was not retained, then it would need to be, one of them would need to be present to present.
That's correct.
One of the current owners, yeah. Okay, just to clarify that. But the board can act, though, on a standing application today or not?
It's
without
not
them
ideal,
here?
but Mr. Sumer has been here for several hours, so as
Yeah.
long as there's an assertion
An
that.
intention, yeah.
Right, that there will be either an attorney or a member manager of the trust present to speak for, who has the authority to speak on behalf of the trust.
Yeah, yeah, okay. All right, so if you'll continue, and then we'll have board questions.
Sure, okay. That's basically it.
Yeah.
That's where I stand regarding the slope integrity and the water runoff.
And collectively, those impacts to the property would cause what?
They would cause harm with flooding, erosion. I mean, when you talk about the impact of heavy rainfall, just from my experience, when you site prep 20 acres, the amount of rainfall that can accumulate in certain spots can be detrimental to the land around you. I mean, that was just on a 10% grade on a 20-acre site. Now we're looking at a much larger development on a much higher elevation. So that's one of my concerns.
Sure. Mr. Freeman, any questions?
Yeah, I do. I have a few. So, can we have either that image back up that we were looking at, or if you don't mind, Mr. Sumer, staying there with me. I'm sorry.
Mr. Chair, can I ask a
Rookie
question?
mistake.
Please.
I'm not sure, I'm confused about this, but are we considering offering standing to the trust?
We will be once Mr. Freeman has an opportunity to question him, yeah.
Okay, but this
Working.
gentleman does not represent, he can't represent the trust.
Not,
So,
not legally, yeah.
so how is Mr. Freeman asking a question of somebody who does not represent?
Yeah.
Who's going to be proposed for standing?
We asked this question just now, and legal counsel does confirm to the board that the board, with the expectation and presentation that the member manager or an attorney representing the entity will be here next month.
So we're giving him like special permission that he otherwise wouldn't
Yeah,
Wouldn't
yes,
deserve.
yes, because he's an heir to the, I mean, he's not an owner yet, but he will be an owner,
Okay, all right.
so, yeah.
And I'm hoping that some questions here may make this easier. You know, if it is complicated dealing with non-entities, I agree, there should be a lawyer here representing the trust. And I'm happy to just tell the board my thoughts or ask them in the form of questions. I know we're doing things a little weird here, but if we can have that map up there, I want to point something out.
Yeah, let's stick to the question Q&A format.
Okay. So my first question would be for Mr. Sumer. Mr. Sumer, do you have any special training, education, or experience in stormwater management?
No, that's why I want to hire an engineer.
Okay. So may I approach the screen and use a laser pointer?
Please.
All right, it works. Mr. Sumer, can you see this screen?
Yes.
So this is, oh, you really can't see it when I put the laser on it.
Yeah.
All right. Do you mind switching
would you
places
like
with
to
me,
move?
and I'll
Yeah,
use the mouse? All right, so if you're looking at this piece of property, this is owned by the trust, right? Where my mouse is, right? This is the subject property, and this is a big ridge that goes between those two pieces of property. Is that correct?
Are you asking me specifics about the topography of the land?
Yeah, and also I'll represent to the board that the majority of the subject property is downhill from the north end of the property. It's only that triangle portion of property that could potentially have any runoff effects on the other side of the ridge. Is that a fair statement, Mr. Sumer?
I don't know the answer to that.
Okay, and I believe that the board is going to hear testimony from an engineer that there is a sophisticated storm tech system that is going to stop water from even going over that ridge at all. It's all going to be captured on site and handled appropriately.
That's the same story we heard on our last property.
Right, and so, and I understand that Mr. Sumer is telling you his experience is that he knows of a project in Waynesville that went south, and he doesn't want that to happen. I understand that he can't be here today representing the trust. I do welcome his input as a witness on this project, as someone who seems to be concerned, and our engineers will be happy to talk to him about this. But in order to get standing, you have to show, first of all, you've got to make a credible allegation, which takes some level of sophistication. The second part is you have to show special damages. And there's just no feasible way that the damages he's talking about regarding stormwater would impact that property. They're going on the other side of the mountain.
Can I respond?
Yes.
The purpose of my testimony today is because we just found out about this a week ago. We just got it, a day before I go on a week trip with my wife. I would like the time to retain legal counsel. I've already spoken with our attorney. I would like time to get an engineering report. Our last one took about 2 to 3 months to get. And I would like that information presented to the board by legal counsel and a professional engineer. I only think that's fair. I cannot comment on the attorney's questions that he's asking me about runoff and slope, but I can tell you that area where the triangle is up top, that is a very steep slope and a downward trajectory towards us. That's the reason why I'm here regarding those two.
I've got a question for staff. When were notices to adjoining property owners mailed out?
March 25th.
Mr. Chair, while they're looking that up,
May
I
20th.
would like to tell the board that the applicant sent out certified mail to the property owners months ago about this. So there was notice given to the proper property owner.
Do you have that date that y'all sent it out?
July 1st, 2025. It was delivered to the PO box of the address that's on file with GIS.
Okay. And staff's notice?
That was on the 27th of March.
Okay. Thoughts, questions?
And you said that was registered mail that was mailed out? Certified?
Yes, sir, certified.
So I don't need it right now, but that would be available if we requested it.
Are they saying certified mail
Certified
to a
mail?
post office box was sent to us?
Correct.
Okay.
And the county had notice too, to that address. Joel?
Yeah, well, besides hearing some discrepancies about the notice, discrepancies about where, said damage would occur, no damage would occur. And also, it's about 17 minutes before we adjourn.
Mm-hmm.
So I think it'd be appropriate to take a look at a continuance. I don't think we're going to finish this at 17 minutes.
Not the whole hearing, no. We usually find a good place to stop, but right now we're talking about a standing application. It's possible for us to get through the standing application and the next.
I agree
next
with
standing
that.
application and not get to the case in chief yet. So it's going to be next month anyway, that's right. So it's the board's, decision on that. You can continue the standings till next month. I don't know what that would do, but.
Our preference would be to proceed with standing today.
We would usually do that if we have 20 minutes left, yeah. Does the board feel either way about that? Yeah, okay. We've got two, we might have another, we'll see. Yes, sir.
Yeah, what we could do is allow him to continue, oh, I'm sorry, Joel.
Joel?
Yeah, okay, so next question is, assuming there's going to be a continuance, okay, the next time it's scheduled, could legal counsel show up for the trust to represent them?
Right.
Okay.
We would, and that's, they would have, in order to present a case at all, in order to do that next month, there'd have to be member manager, an owner, current owner of that trust, or an attorney, so.
Yeah, well,
They couldn't-
whether it's next month or the month after
Right.
that or something, but as long as they have the opportunity,
That would be the expectation.
okay.
Can we continue can we continue the application from the trust for standing until next month, and this month go on to the next applicant who's here?
We could, if we did that, then next month, anybody who wanted to assert standing could apply and assert standing next meeting as well. So we wouldn't be able to close up standing at this meeting. That's the downside of that. We could do that, though.
But I'm not sure I understand how we can rule on standing if the applicant for standing isn't here.
We would be informally ruling that they be allowed to join the case as a member of, as a party with standing, and that next month, either an owner, current owner, or an attorney, again, would appear in lieu of Mr. Simmer.
Or in addition to, correct?
You could appear, they could call you, and you could present as well, yeah.
Mr. Chair,
Mm-hmm.
that does sound a little like special treatment to me. This notice was properly given. Also, notice was given to the legal entity months ago by this applicant. What you have before you today, I think we should just treat it very simply. You should look at the standing application that's in front of you. It is legally defective because it wasn't signed by an authorized member of the trust, and the evidence that's been presented today is insufficient. Our request would be to be treated like every other applicant that's before the board. Rule on the standing request, let's move on to the next one, and do a continuance in the normal course of business.
So with 15 minutes left, your argument is that we should wrap up standing today, but that we should not allow this party to have 15 minutes time or the beginning of the next meeting to come with an application for standing that's correct?
I think I concur, because technically, this young man who was very well-spoken and apparently tired from an airplane trip, he is not technically a representative. So in our eyes, why I see this man in front of us.
Yeah, I agree.
He's not technically
I
allowed to be a
completely-
representative.
Completely agree with that, and if the board feels that
That's
way.
unfortunate, but that is the reality.
If the board feels that way by majority, we can absolutely move forward next month doing standing application for this particular applicant. When the owner or the attorney is here to present that, I'm fine with that. The main applicant here today just asked for us to wrap up standing today if we could, applications, and that's what I was responding to, with the expectation that they would appear next month with the proper folks here. But I'm fine to delay to next month, absolutely.
Well, the counsel for the applicant, you bring up the issue special treatment. It looks like we're gonna have to continue the case. So let's say the people that trust legal counsel show up. Is your argument gonna still be we're giving special treatment?
I think that what we're asking for is just a ruling on the standing application that was submitted, so we can move on to the next standing application.
Right.
And we'll decide what those next steps are after that.
If I'm a beneficiary of the trust and the trust documents, does that exclude me?
That's not a legal way, in our opinion, that we can hear your testimony as a standing applicant.
If a managing member or someone in the trust were here next to me, would that qualify?
Yes, they could present the case.
Would we still be able to come in and?
They would have to present the case, or an attorney. An attorney could call you and all that, yeah. But the member manager would have to present,
I understand, okay.
right? So, yes, sir.
Yeah, let me just comment that what the applicant's attorney is calling special treatment, I would call discretion.
Right, we can move past that and kind of think about the main case, which is, should we vote on this one at all today? Should we just push this matter to the next meeting so that they have an opportunity to come with the appropriate representation to have the board consider their standing request? I would hate the board to vote right now on the standing request and next month have them resubmit it. Right? That's unfair. Yes.
May I point out that the standing application that was made by Mr. Sumer, so you are denying his standing application. It's not anyone else's standing application, Mr. Sumer's standing application.
That's absolutely right, yeah.
That's all we're asking for, is a ruling that he does not have standing.
Okay. What does the board wish to do here?
But it's to the board's discretion.
Is it correct to say that
The
it would be?
an incorrect person is on the request for standing, so you could act on that. Yeah.
Is it too much to ask to say, we're going to deny his request for standing, but we're going to allow one entity to ask for standing next month, and that's the trust?
I don't believe that's within our rules of procedure would discount that as a possibility, I think. If we opened up just next month for one standing application and not any others, the entire audience have to be polled, yeah.
Yeah.
Just submit 30 more or whatever, whatever. So, but we're fine, we can act on this one and deny and have the entity come back next month, yeah. We can do.
So I just want to clarify that statement, Andy. If we can make the clear-cut decision today regarding this gentleman's request for standing, we've got another individual who's asking, and it's going to take probably more than 12 minutes to do that, and we'll be at the end of the day, and we will not have gone through all the applicants for standing. And then we will continue this until the following month, unless somebody wants to extend it further. But at that point in time, someone can come in, AKA a trust, and ask for standing at that point in time, can they not?
They can.
And asking legal, is that correct? I mean, resetting the clock next month will allow somebody else to, that they did not have to be present at this hearing to be able to speak at the next one because of the continuance.
Once the case is continued, it's continued and you start fresh.
Okay. All right.
Yeah.
Then I make a motion.
Motion to deny this gentleman's request for standing.
Okay.
Second.
There's a second? All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? That passes. Thank you. And our next standing applicant was, help me out. Tabitha. Thank you, sir. Yeah, we're getting the weeds on that one.
Okay, please raise your right hand and state your name.
Joshua Ty Battenhorst.
Do you swear and affirm to tell the truth and nothing but the truth?
I do.
Okay, thank you.
Welcome, sir.
Hi, good afternoon. First of all, just thank you all for your service to the community. I really appreciate what you're doing, the time that you take. I've been on some boards of my own. I was a member of the Asheville Area Arts Council for 6 years, and I know it takes a lot of time, so I appreciate what you guys are doing. And it's clear that you and your staff and obviously the people in this room really care a lot about our community and want to see the best possible solution taken care of. And I'm glad we have a government order that allows us all as neighbors to get together and see what's the best thing to do. So I have a number of concerns. I know that those are better spelled out either as a witness or if I'm given stand-in during those statements. So I'll stick to what I think is a pretty simple application for standing because which it really boils down to this. I appreciate Mr. Suggs having the neighborhood meeting via Zoom, and my concern where I became aware of my potential for having standing was during that neighborhood meeting. My property, as I was getting this together, just to kind of give you an idea of the location, my name is, again, I live in the property at 255 Edgewood Road South. It's across Sweeten Creek Road. It's that little parcel there, and I'm a neighbor to that parcel. As I was preparing, I'm also kind of an amateur astrologer, and I was preparing, the moon was in Sagittarius 28, which is an old bridge over a beautiful stream is the image. And so if you imagine yourself driving out Sweeten Creek Road, where the road narrows down to 2 lanes from 4 lanes, and they're not too long, you have that beautiful little old bridge of the Blue Ridge Parkway that goes over Sweeten Creek Road. And this is the area that we're talking about. And my property would be, if you're driving away from town, right there on the left. And adjacent to what's proposed. During the neighborhood meeting, I asked Mr. Suggs what's planned for there, and he said that there's nothing planned for there unless something comes up about stormwater and they need to do some mitigation in that area. So I didn't see that covered necessarily in the application. And so I would like to have the opportunity to ask my questions to the applicant. I have other concerns about the application that have come up as I've been able to look at it. And it's just kind of it's unfortunate, I think, the order of some of these things that you guys have to get so far down the road before we get to, have a conversation about, how it's going to affect. And I know that things would come up. So I would like to have the opportunity to have standing obviously at the next meeting at this point in order to ask those questions. And because we're just having a parcel as a parcel to the zoning application being, the special use being approved, it feels like without a plan for that piece too, we still need to, there needs to be some back and forth and some clarification made about what the potential, because again, as it was related to me during the neighborhood meeting, they don't really know what the potential is for the damages to me, because they don't really know what they might have to do in this possible case where they're just trying to reserve the right to do it at some point in the future at this point. So I'd like to have standing in order to have my concerns further further examined through cross-examination and you know, and there's other things as well. I mean, I walk my dogs every day on that property, right on the Mountains to Seas Trail, and I know dozens of other people do as well. But you know, that's my house. That's where I go, and you know, they're really trying to build it right up next to the trail. So we need to. I'd like to have the opportunity to really dig in and see if this is really the best use for the community. As my neighbors are trying to, you know, extract some value out of their property. I understand.
And sir, can you clarify your location for the board? Is it Edgewood South?
Yes.
And whereabouts on that?
Yeah, so there's a little jut that you see that goes across the road, and my property is the property just to the east of that, and also to the south of that.
On the panhandle.
So, and also in the plat, when I bought the property in 2013, Chris and Beverly Taffer had applied and gained a right-of-way that goes a 20-foot right-of-way to access my property across their property as well. So that, I want to make sure that it conveyed to me when I bought the house, and, you know, in any future, you know, potential use for me of my property on that side, I'd still like to make sure that right-of-way is also protected.
Okay. Questions?
Yeah, thank you, Mr. Chair. Mr. Batenhorst, Batenhorst, I'm so
Sure,
sorry,
no
Mr.
problem.
Batenhorst. So I'm looking at your deed here. I just want to make sure that we're on the same page. So there is a road, and do we have a picture of the site? Can we look at that again, Madam Producer? We put it up there. Is this too close to, for comfort to you?
No, you're fine.
Okay. So, use my right hand.
Yeah, good.
Oh, goodness.
You're doing great.
Thank you. All right. So I believe this is your property where my cursor is. That right?
Can we zoom in just a little bit?
Yeah. Now I
pretty
should be able to see it now.
Yes.
Yeah, okay.
Yeah, so this section right here to the east and then
Yeah.
to the south, and then a 20-foot right-of-way there.
Right. So, but your deed says that what you have is an easement that starts at Edgewood Road, which is up here, and goes southeast. And it goes to the property that sold you this parcel of property. Is it the Taverners? Is that right?
The Taffers?
The Taffers. Okay, so the Taffers are to the east of your property. So this is where your easement is. So
No. The easement is here. It's at the edge of, it's on this.
So that's not the one that is mentioned in your deed.
I think it is.
I will read it to you. But in any event, the easement that your deed references is this. Let me read it to you. It might
That's
clear
not
it
the
up.
same as the right-of-way.
Right. It says you have a perpetual, non-exclusive right-of-way over that certain 20-foot right-of-way running southeast from Edgewood Road Extension to grantor's retained property. So that's what I'm talking about. That's the Taffner.
That's not the same easement. There's another one.
This is the easement of
Do you wanna
record
look
for
at
your
the map?
property. Well, if sir, this is my opportunity to ask you questions if you don't mind.
Sure, go ahead.
Okay.
Wait till he gets back
I
to
think
the
we
dais
can
here.
move on with there is not, he does not have an easement
That's
in
incorrect.
this property.
That's just incorrect.
Let's keep it to Q&A.
Okay.
If you can produce something, that's great.
So,
Go ahead. I can listen.
right. All right, do you have what plat you're talking about?
Somewhere in here.
Okay. Is it plat book 97, page 66?
I think so.
Okay. So that is what is mentioned in your deed, and it doesn't reference that easement. Is that fair to say?
No,
Okay.
I would disagree.
So the other questions would be, what What training or experience do you have in stormwater management practices?
Experience, I was the development director at Art Space Charter School when we had stormwater flood, and so I worked hand in glove with Mike LaVoy and some of the other folks that do stormwater management. Learned a lot from that, so that's experience, but I'm not, a stormwater expert.
Right, when it came to making stormwater decisions, you relied on those experts to help you, correct?
I sure did.
Okay. Those would be my questions right now.
Thank you.
Okay. Board questions?
I guess really what I look at here on the, I'm sorry.
Yeah, please.
Sorry. Is we're approving, if we're approving what's presented to us today on the plan, there is actually no improvement shown on that panhandle and if there were improvements added to that we would have to come back to this board. Is that?
As far as the house, you mean?
Yeah, as far as any improvements to that land, it's not showing on that. I'm asking the question for the board, for the rest of us just to ponder, because I'm not seeing.
My mind was on the same thing.
Yeah, I mean, we're the master plan, there's a master plan we would approve. There are no land improvements across Sweeten Creek Road on that parcel at all. It's reserved for future use. If that future use comes to pass, it's got to come back before us to modify
It
it.
does. I
So,
think the concern is about
just for-
stormwater runoff, so on that property, it's vacant.
And it's separated by Sweeten Creek Road.
yeah, it's separated.
Oh, so
by-
it's-
It's separated
it's
by.
entirely
by a
separate
public
area.
Public road. It has its own.
If there's no culvert there, I assume we're talking about the potentiality of putting in a culvert.
Yeah. When I see future development, it's
Right.
future improvements.
Right, exactly, yeah.
Conveyances are, will be part and parcel of the plan we approve on the other side of the road.
Sure. Other thoughts? Hearing none, ready for a motion?
Motion to deny standing.
Motion to deny standing. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? Thank you. Passes. And anybody else here to assert standing today? We'll continue on with that question again next month as well. And anything else from staff today?
I just wanted to make sure that this individual knew if he'd like to speak as a witness next month, he would be able to.
Oh, thank you. Yeah, we have a witness testimony time next month as well at the end of the case.
Okay, thank you.
This will be, the case will be on the first on the docket. So, all right. Anything else from y'all today? Y'all set? Okay. We're all set, yeah?
Motion
Ready?
to continue?
Motion to continue. Is there a second? All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you.